Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican for service watching.
That's literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you. Sorry, had a little good to have you here. I had a little bit of a technical glitch at the beginning that I was trying to defeat after I had gone live. So a little bit of a delayed open there. All right. Good morning. Hope you're all doing just fantastic. Yeah, sound someone with more experience. I hear that. But this is all you got today. I'm what you got. I'm not saying I'm the best, but I'm here. So, good morning, one and all. Let's see. We've got who is this? Shmoopy, first in chat. Congratulations, Shmoopy. It's been a bit. I think you've won before, but welcome back. Welcome back to be on the leaderboard, and welcome to your punishment. We're going to send it to you to internet ownership for your promptness. Everything IP related worldwide is your responsibility. There we go. Given away. Done, and one and done. Before we sing happy birthday, I just want to hear this. The Judge Middleton is going to tell us about just what a beautiful day it is, and let us know, where we are in life and today and everything else. So just Judge, if you can just weigh in quickly. Your cue, Judge. Go ahead. Your turn.
Today is the first day of autumn.
Yes.
We certainly had summer right up until Saturday afternoon.
Mm-hmm.
Time for everybody to pack up, put their boats inside, and take their docks out, and take care of their fall plants. Wait for dreaded leaf raking season.
Oh, man. Thank you, Judge. Appreciate that. That's a great way to start the day. Wait for dreaded leaf raking season. All right, we are here. A little public service announcement from Judge Middleton. Take your boats out, pull your docks out. Leaf raking season is almost upon us. All right, good morning. Good morning, one and all. Dancers are stretching. Thank you very much. Getting ready for the birthday song, which we'll have here in just a little bit. I got a fun little, hopefully, fingers crossed for a fun little court. It might go south really quick, and we might have to bail. But we might have a fun little court just lining up for us that's starting today. So we've got our fingers crossed. Let's see. Nikki Zeebs, love my RA fam. 29 months, Nikki. OG. That is awesome. Nikki, congratulations. 29 months. That's it's huge. We've got Karen's civil trial today as well. That might be one we go to. Honestly, that's on the burner. That's on the back burner. We're trying to just wait and see which one tends to deliver better. I don't rake no stinking leaves, just mulch them. We're not going to cancel court to go rake leaves. Did everyone have their mandatory earth, wind, and fire listening yesterday? We got a lot of stuff going on. Oh, here we go. There's our birthdays. Thank you very much, Josh, and everybody. It's a group effort getting the birthdays together in the morning. So we have a list that has Christy Collette, Ellen, Mike, Mimi D, and JC on it for birthdays. So
Happy birthday. You look good.
Thank you. You look good as well, Judge. Thanks for weighing in. All right, so we're going to sing happy birthday to Christy, Ellen, Mike, Mimi D, and JC. Everyone stand up, take a rip. Abadi. Got to warm up my tongue. The quick, sly fox jumped over the... I don't remember how it goes. All right, everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor. Warm up with me, if you will. La 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 la. We're good. Happy birthday to you. Happy birthday to you. Happy birthday, Krista, Colette, Ellen, Mike, Mimi D, JC. Happy birthday to you. All in one verse. That was awesome. We did it. First try. To everyone who is celebrating their birthday today, happy, happy birthday. I realize there are a million places you could celebrate and a million people you could have celebrated with. But you chose to be here with us. Privilege, pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. There we go. Yeah. Happy birthday. Happy birthday, all. Dancers doing their thing. Trying not to distract from these moves. They've been practicing all weekend. Seems strange not to have any late ads to the birthday song. Barbara, now you know. Bob Evans Restaurant. Free pancakes. Josh says don't say that yet. What do we do with the extra time? Stress-free Mondays are okay with me. You guys, I'm impressed that everyone got their birthdays in on time. That was just awesome. We have to do the drums. That's right. We can focus on the drums. Let's do that. Shelly, here we go. Beautiful. That made up for last week when we had one where he couldn't do any drums. I think that was last week. But lots of stuff going on today in the world of courts. We might have to put two screens on and just put one ear being one thing and the other ear being another. I don't know how we're going to do this. It's going to be wild. Judge Dad is doing his thing this morning, just getting started. Hey, Judge Dad.
Sorry, everybody. Give me 1 second here. What is going on?
I know. I was asking the same thing.
Where's my picture? There I am. Okay. All right. LVNV versus Judith M. Weaver, 2502129. Ms. Weaver, are you out there?
Yes.
Okay. Your name?
Judith Weaver.
And Mr. Barta?
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
Did the two of you talk? Have any discussions on this?
Your Honor, I apologize because I have a feed in front of you this morning. I'm just pulling up this file, and the first thing that I see is that this has already been resolved, and a consent judgment was sent to Ms. Weaver on September 2nd, 2025. I don't know if she has received that yet or if she needs us to send her another one, but it has been resolved.
Do you have that document, ma'am?
No, I do not.
She's like, it's been resolved.
Did you email it or mail it by UPS?
We mailed it to 2353.
Oh, I already got hit by YouTube last week.
173, but I can email it to her if she wants to give me her email address.
Sure.
Okay, we're gonna skip. Let me tell you why. I got bonked on the head by YouTube last week because of a terms of use violation, harassment. I harassed somebody by doxing them in court. I doxed somebody in court. I went back and played the video. We were in Chicago, the judge that sits inside the glass box, and I was editing out somebody's phone number, and it had too many digits. And YouTube's like, that's it. You're harassing, you're encouraging, inciting violence and harassing people. I haven't yet fought them. I'm going to fight them on this one because I sure as heck didn't do that. Plus, the person willingly gave their own information on the internet. It wasn't me giving it. It was them. So, there's that. All right, we have a couple things to go to. Let me see if we can get... What time does Karen Reed's thing start today? Does anyone know off the top of their head? The civil thing. You know the one. 2. So that would be this afternoon. 1 p.m. Central, 2 p.m. Eastern. Thank you for that. So before that, it wasn't a complaint, by the way. Nobody complained. It was YouTube's automated system. Watched, and I had to go back and watch. And it hits me with the ban hammer, and it deletes the video, takes it down off the internet. So it's not something you can go back and edit out or something. It's like, nope, it's gone. You broke the rules. So I have to sort of fight him on this and get it back. So YouTube has the AI thing going on. I am super excited. Let me take this moment while we wait for courts to start, because it's just a couple minutes early. While we wait, I am super excited for so many of the things that YouTube is bringing out. They have a huge rollout of new features, which I haven't been able to talk about till now because I was on some of the product testing groups when they first came out of it, and we were shaping it and changing it and making suggestions, and so I was on some of those panels. But some of the things that I got to work on before, this is going to be so cool when it works. They're coming out, and they'll be rolled out here soon. So super excited about that. But that at the same time, some of the AI stuff that's coming out, I'm super not excited for. Not excited. Anyway, hopefully not gambling. No, that's not it. They're rolling out. Everyone is trying to get on the AI bandwagon, right? And they're just making it really easy to just make low quality video, AI generated low quality video. And yeah. But it also is doing some things like letting us live stream and automatically push it both vertical and horizontal. So I could live stream like this, and it will also make shorts. Like the short feed, it'll appear there as well. That would be good. That is huge for visibility for a channel, because shorts have so much more visibility than those wide form videos. It's just the way the algorithm works. But that's going to be big. Authentic content will be the future, 100%. I think true authentic content is going to shine and stand out because it is real and because it is not spoon-fed crap to the masses. Thank you, Barb. I'm not fighting YouTube. I'm fighting the ban bot. YouTube's pushing more auto moderating. Yeah. It's doing all sorts of fun stuff. So, all right, we have a court to go to. Obviously, Karen Reed's this afternoon. We've got this one in the morning. Look familiar? Warren County. We've got our fingers crossed that this turns out to be a good one. So it's supposed to start at 9, but nobody is there. Josh, are you concerned about this? Should I be concerned? That's a live feed with nobody there. I did see somebody earlier this morning just poking around, setting up computers and things, but maybe they'll be a little bit later. So we'll keep our eye on that. Warren County is one where we have to catch it while it happens, so we'll go over to the other channel.
There's nothing in the order that restrains you from talking to cats.
Thank you.
To look for something else. Let's see what's happening here. And 8. It's a different one, different Warren County. Same courtroom, same courthouse, I should say. Are we sure it's in courtroom 4, Josh?
Are we going to address subject matter jurisdiction?
Jamie C., is it true that AJ has more evidence nobody has heard yet about what is used in the civil case? I believe the rules of evidence for what is admitted in trial are different for civil than criminal, possibly. And so there would be things that would not have been brought in during the criminal trial that could be brought in the civil. But I don't think he's got like some smoking gun that he just held back because he didn't need it in the criminal trial. Josh, thank you very much for doing a little digging. I'm on 4, but this is 3, I think, we're looking at right now. You see the Icelandic sweater? Yes, it looks great in the front row. There's a better view. Okay, now it looks more like a Tommy Hilfiger. Yeah, it's a Tommy. It's a knockoff. It's a knockoff. It's not true Icelandic sweater knitted out of yak's wool or something. It's fake. Kayla said court 3. Okay, well, maybe let's go over to court 3 then, because it's well, we're in court 3, but I want to take the other feed over there. Just one second. Go into 3. All right, so we'll jump to 2 right there. That'll free up 8 to do some court hopping. Y'all can see the court still. We've got audio. Okay. Kayla, we're in 3. Josh says, there are trials in 3 and 4, but we need 4. Court 3 is the trial we don't want to touch. Oh, man. It's the bad one. Kayla, you're leading us astray. 4 has nothing. So we need 4. There's 4. Four does not show, it just shows common pleas court, right? Oh yeah, it's courtroom 4. That's the one. You have to search for the 4. Okay, we'll keep sort of watching this one until we have to bail. How about that? So I got a call on Friday. I didn't take it on the air. Asked for me by name, my real name, not Dwayne, first and last name, and started asking. There's a headhunter. You know what a headhunter is? They're like people that try to fill a job application with, you know, just the right person. They take a little fee on the front end. We started basically a preliminary interview, asking about the job. I was asking about, you know, how many people I'd be supervising. It was for an unnamed company that deals in high-end industrial explosives for mining. And I'm like, okay, so it's in my same field basically. I'm not like making a big transition, and so we talked back and forth. I asked about the pay, and they said, you know, they're obviously they're looking for the right candidate, and I said, then you must be, you know, willing to, you know, to negotiate the price. And we got like pretty far along, and then they told me just one aspect of the job, which I didn't like. And I asked if that was negotiable, and they're like, no, that's pretty much the whole thing you have to do. That's the part. That's why we want somebody to do this. That's the hard part. And I asked if we could split it up, and I take half the job. And at that point, she got a little. She was a little confused. The terms I was using was not matching up with the terms she was familiar with the job. And then I said, you know, I currently manage a team of about 67,000, direct manage 67,000, And I just can't see myself taking that big step back to just 220 people. And she's like, you managed 67,000? I said, well, I'm a YouTuber and I have that many subscribers. She's like, and your name's Scott? And she used my whole name. I'm like, yeah. I said, and you work at this company? I'm like, no, that's not me. You got the wrong Scott. Maybe he wants the job. Maybe you should call him. It's pretty funny. Okay, we have to bail on this court as much as we liked watching them organize.
All right, this is the case of the state of Ohio versus Tyler Deaton, case number 24 CR 42060. Present before the court is Mr. Deaton.
A plea was taken.
Correct, Your Honor. Represented by Mr. Brenner. We have Ms. Kraft and Mr. Knippen from the prosecutor's office. We are here today for a bench trial pursuant to a jury waiver that was filed June the 23rd.
Bench trial.
Anything preliminary come to my attention before we get started?
Your Honor, the state would move to designate Detective Abshir as state's representative. Cecilia Rodriguez is here. We would move to have her be the victim's representative. We already did that at the time of the depots. I am a little concerned. Tim Deaton is one of the state's witnesses. We just advised him he had to wait out in the outside until he testified.
Major.
And he was frustrated with that answer and indicated he would end up watching it out there. I don't know that he has a capability to do that, but
he does.
We've instructed him that he's not permitted to watch, and he indicated that he was going to.
Your Honor, it's been indicated to me he's sitting right outside the courtroom. I think he was just frustrated. I don't think he intends on violating any order of this court.
Right now, we don't have a separation of witnesses request,
The
do
state
we?
would move for a separation of witnesses, Your Honor.
I was also going to make that request, Your Honor.
Oh, good. They both
Okay,
agree.
so
This is a bail immediately one,
why don't we just call
unfortunately.
Mr. Deaton first?
This is I think it's a SA situation.
We've already had this trial in two other tiny segments. Is there any reason not to do that?
This is Warren County Common Pleas Court.
Okay.
3.
Any objection to the victim representative being in court despite the separation of witnesses order?
No, Your Honor.
Okay. Because
So-
usually I
so
would
look,
require
here's-
a victim
this is the court.
representative who is not the actual victim to testify.
There we go. I'm going to mute it. We're going to jump from this one because it's content that we don't follow on this channel. Warren County Common Pleas Court, Courtroom 3. That's the YouTube channel you're looking for if you do want to follow that one. But
we tried leaving a couple messages, no response. Judge, I guess what we'd like to do, I mean, I can submit a default judgment with that $100 monthly payment plan. I'm still agreeable to that. We could make the first payment due, October 15th and just see if she.
Well, did she make any payment?
Well, there was a payment made, and now I can't really tell if it's. So we got a payment on June 10th, and then I see that another payment was attempted. It says July 6th, $100 Visa payment declined, canceled recurring payments. I just want to confirm that the payment that was dishonored was not the first one, it was the second one. But I'm happy to do that and submit either a default or a consent, I guess a default with payment plan. If she's
Well, I have a
interested in it.
default here.
Yeah.
The question is, do I apply the $100 June payment to the amount?
I think so. Yeah, Judge, I think so because, and looking at our account ledger, it does show that the $100 payment was made and it looks like it's been credited and remains credited. The reason that we jump up is the cost. So the cost is sort of offset by the total.
So it
Yeah,
shows
Judge.
$875, payment credit $100. So this default of $945 is the correct amount?
Judge, I think I'd feel more comfortable if I could submit a different judgment just to confirm. And I don't mean to make more work for the court. I know you're trying to take the path of least resistance and take what's in front of you, but I feel much more confident if I could submit a new one where I check with my accounting staff as to the status of it. But I'm it looks like a payment's been made. And then again, I guess we can.
All right, well, let's do it by default with payments at $100 per month.
make the first?
Starting November 1.
Okay. And then, I don't remember. Just trying to look at, is this an e-filing court? No, I don't recall.
No, it's not. You
Oh.
can simply email it to us or
Okay.
send it on a 7-day rule.
I'll email it this morning. That would be probably the most efficient way. But I will just incorporate I believe the $100 payment plus the payment plan,
Sounds like
effectively
he's not
turning the
prepared.
consent judgment that I mailed her a month ago into a default judgment, and then just see if she wants to take advantage of the payment plan that she's already offered to make.
All right, let's go back to Judge McNally.
Very
then.
good.
Let me just make some notes.
Judge making some notes. We came in at the right time.
Not yet, please.
Don't talk. The judge is making notes right now.
There's nothing else to say. I mean,
Oh, he wants to say something, though. The guy at the little lectern. He's got some words right there on the page. Look at the tilt of the head.
really nothing else to say. I don't know what you want to say. You're going to have to talk to him, see if you can resolve it. You can't just let these things go like this, sir. I mean, I helped you on April 7th. I went out of my way for you, and you made one payment, and this is September. That's 9 months later.
That'll be this
5 months
afternoon.
later, rather. Okay? I would suggest you talk to Mr. Sherrill, see if you can work something out, but do you work?
Sir,
Where do you work?
plumber. Today.
I don't know what else to tell you. I'm sorry. Good luck to you. Thank you. Send your order over, Mr. Sherrill, please. Thank you.
Will do, thank you.
Philip, let me take Mr. Do we have Mr. Mayer's case at 8:30? This is Concord versus Sophia Norris, 2503110.
Good morning, Your Honor. Ralph Mayers, P23815, appearing on behalf of the plaintiff. And I have good news for the court. No drama on this case, Your Honor. We're withdrawing our motion for issuance of a writ. As of Friday, I talked to the office and the defendant became current.
Okay, would you prepare an order for me that indicates, again, defendant filed a motion to stay the issuance of the writ, and the parties have resolved the matter. It is hereby ordered that the parties agree that payment has been made and that the case be dismissed without prejudice.
Very well, Your Honor. I'll submit that order.
Is that all right? Or you want me to do something else?
No, that'll be fine, Your Honor. I'll submit that today.
Nice to see you, Mr. Mayers, as
too.
always.
Thank
you.
you. Okay. Take care.
I'm going to take, this is Sophia Norris, Philip Trefibio versus Mariah Stennant, 2502959. I just saw Mr. Trefibio out there.
He's on Zoom, Your Honor.
Yeah, I don't see him right now.
Yep, he's there.
Where?
Oh, I'm sorry. Jeez. And there's only 5 of them, not 19. Mr. Trefibio, only 5 of them, not 19. Mr. Trefibio, your name?
Philip Trofibio.
Your name, ma'am?
Mariah Stennant.
So I entered a judgment back on September the 2nd or thereabouts, and the writ date was September 12th. And it looks like on September 12th, you filed a motion. Do you have the money to pay this right now?
So my caseworker is working on getting my landlord registered as a vendor to accept the payments. It has to be made directly to him. And then going forward, I'm back full time at my job, so forward won't be an issue.
I just can't, ma'am, you're not entitled to any more adjournments here. Out of courtesy, I set this for hearing. This was brought to my attention on about Thursday, and I told them to set it for hearing.
Right.
On August the 4th, you came in and said you made an application for funding. I did what I was supposed to do when I adjourned it, and then it was adjourned again from August the 18th. And then on August the 25th, I adjourned it again for another week until September 2nd. You're just not entitled to any more adjournments unless Mr. Trefibio here wants to agree to something. I can't just make my own rules up here.
The reason why the payment hasn't come through with the state yet, I had two parts of my application. So all these were like in the same thing. My DTE and my rent, both I applied for, they did make the payment for DTE, but they can only process one payment at a time.
Who'd you apply with?
SCR. Who's what?
Who you applied with the DHS?
Yes, directly through my DHS caseworker. And I have the proof of the DTE that was finally processed.
You want to go call your caseworker right now?
I was at my caseworker's last week, and she told me that the only thing that I can take is this, which is the approval, and then
I can't, ma'am. I just can't do anything. Mr. Trefibio, what would you like to do here?
Your Honor, I'm asking for possession.
They got to move these along quicker. I can't just extend it forever.
I understand, I truly do, and I'm just humbly asking.
I can't make my own rules. I mean, you owe them $3,500, and does that include even the $34.99.95? It's a lot of money. How much is the monthly rental rate on this property again?
1,100. So it's July, August. And
If you tell her to call in or log in, and if she tells me she's going to get a check to Mr. Trefibio today.
she can't, she has to get him registered. She sent correspondence to him directly to have him registered as a vendor.
Hang on, slow down. Did you receive that correspondence?
Your Honor, I have no idea what that was about. I have not received any correspondence from any government agencies whatsoever.
Right, I was just down there at the end of.
Well, she might have said that. If you want to have her log in right now, she can log in.
It takes hours. I wish I could. I
just can't. I can't.
But it takes hours for them to even answer the phone. That's why I went down there in person, and called off work to go down there.
Can you?
I know. I wish I could give you something more. I truly do.
I know you do, and I feel horrible about this. But the guy has $3,500 owed. He's about to get up to $4,600 on October 1.
Well, that's not gonna happen, because I'm back at work, so I've been paid. I have two jobs. I work at Texas Roadhouse and Greenland Market. Like, I'm fully working again. My foot's fine. They had to process this payment first, which I have and the proof of. And now they need to register him to be able to process my rental payment.
We'll get her.
And that's the course.
They know.
They're sending.
They know. They know how these things work.
They do, and I gave them the judgment date and everything.
So now, since you applied for funding according to my notes, before August 4th.
I did.
So now you are up to what? 49 days. And they still haven't come through with the money.
Right, for one part. One part's completed.
DTE's completed.
Right.
That has nothing to do with Mr. Trefibio.
Right.
Ma'am, I am not unsympathetic. I just cannot ignore laws like this. I'm not going to do that. I cannot do that. If Mr. Trefibio wishes for me to do that, I will do that. I feel horrible about it. I can tell you're upset. I don't relish in having people leave their homes. That's not a fun thing as a judge. But I can't do it. I really am sorry. I mean, I just am sorry. He's telling me he didn't receive anything from them.
I know, they just did that. So the letter that I received from them, my caseworker, and just clarifying like the first payment that went out, I didn't even get this until 9/11.
That's the DTE.
Which is the day before my rental judgment was due. So I went down there immediately It kind of freaked out, honestly, because it's taking so long and I'm gonna lose my house. And she said, well, this is the process we have to follow. Also, we know that your landlord's not registered as a vendor.
Well, why didn't they tell you that 8 weeks ago?
I had no idea. And she said, we obviously checked to see if he could receive payment. He's not registered.
If you think you can go and get somebody on the line right now,
I mean, I could
try and then come back in. Mr. Trefibio, I'm going to ask you to stand by, but they got to move over there. This isn't, nobody would like not receiving their paycheck. They got to move. I mean, okay, go make a call. Mr. Trefibio, just stand by for me, will you please? Thank you.
Thank you.
Thank you.
Capital One versus Brian Phillips, 2501456.
Good morning, Your Honor. Cezanne Barta, P 65425 on behalf of the plaintiff.
All right, sir, your name?
Brian Phillips.
Did he ever sign it?
It starts at 2 this afternoon.
It says, I said this on August 26th. Parties reached tentative agreement. Defendant has failed to return. 3, I don't know what I can't even read my own writing. 3 documents. I don't know. Or proposed conditional dismissals or judgments. Did you send it back?
I don't recall if I did or didn't, to be honest with you.
Okay.
But right now, I'm trying to find a job. I just got.
Do you have a lot of these going?
What's that? Do I have a lot? No, I just said this is the only thing I know about going.
Did you email or send him the tentative agreement?
I got paperwork.
Slow down.
Yes, on July 30th, we emailed the conditional dismissal to Mr. Phillips. His first payment was due September 1st and it was never made.
Like I said, I just lost my job.
Slow down.
20 minutes.
Slow down. I have to get this case resolved.
No, and I understand.
Okay. So it sounds like you agreed to a conditional dismissal. You didn't send it back. And now you've already violated the terms of the conditional dismissal, which I'm sure, according to the conditional dismissal, allows them to go ahead and set aside the conditional dismissal and submit a proposed judgment. Right? Those were your terms, right?
Correct.
So I don't know what everybody wants me to do here. I mean, you want to enter into this conditional dismissal or not?
I want to get it done, taken care of. I just, like I said, with me.
Listen, we're taking one thing at a time.
I have no problem. I'll get the payment set up. That's
come on. He sent it to you 3 times.
So close.
And then I adjourned it 3 weeks, and here we are. Actually, they adjourned it 4 weeks. What were the terms of the conditional dismissal, Mr. Barta?
I'm going to try to get away from these landlord
Hereby
tenant
ordered,
stuff.
Judge, the defendant shall pay to plaintiff the sum of $5,589.26 in monthly installments as follows.
Let's go to
$100 on or
Judge
before
Middleton
September
again.
1st, 2025.
I can open everything else in there, but I can't open that. So I had the same thing inside. I'll check it when we get done here. All right, we return to Three Rivers Health versus Tanika Bowers. Mr. Robert Conley is here for the plaintiff. Ms. Bowers is here. Parties were put in a breakout room to discuss the matter. The claim is of some substance. It's $3,000 plus. Typical kind of bare bones pleadings. The date of service was alleged to be January 5th, 2022. So it's 3.5 years ago. Mr. Conley, what's our status here today?
Ms. Bowers and I had a chance to talk, Your Honor. We have come up or agreed to a payment plan on this balance of $200 a month, starting October 15th and the 15th of each month. Now, I did submit a default judgment back. I don't know if you have that or if you want me to file a consent judgment. She's given me the authority to sign her name to that if you want me to do that, or you just
All right, well, let's do that. Well, let's make sure we got the numbers agreed upon. $3,045.25 is the claim. Costs are $121.37. The attorney fee is $75 by statute. The total amount is $3,241.62. Do you
Yes, sir.
agree with that figure, Ms. Powers?
Yes.
And you agree to pay at $200 per month starting October 15th and the 15th of each month?
Yes, sir.
Mr. Conley, I would ask you to send me a consent judgment noting that defendant consented on the record to the terms of the agreement. Are you still at East 5th Street in Constantine?
Yes, sir.
All right. If you can pay more on this, the sooner you get it paid off, the sooner you won't have to deal with it. This will take a little more than 2.5 years to get this old bill paid, but it would get it resolved. Mr. Conley, I'd ask you to send me a consent judgment and I'll sign it and we'll forward it to Ms. Bowers. She's got her information on where to make the payment.
Yes, Your Honor. We went over that in the breakout room.
All right. Very good. Ms. Bowers, do you have any questions?
No, sir.
All right. Thank you for your patience. And Mr. Conley, I'll see you next time.
Yeah, I apologize to both of you.
Well, if you had an accident in your family, there's nothing you can do about that. So it made more sense to just keep her here, but we did resolve the case.
Thank you, Judge. Thank you, Ms. Bauer.
Yes, sir. Thank you.
All right. Okay, we got that one resolved. Very good. Whoops. Let me remove Ms. Bowers.
Miss Bowers has been removed. So sort of a quiet morning this morning. Karen Reed this afternoon. That'll be exciting. How's everyone's weekend, by the way? Anybody do anything really fun?
I'm in between the next one at 9:30. How's your morning?
Good. So far.
We're clunking along like we usually do on Monday mornings.
For what? What kind of case?
General civil pretrials every 15 minutes. So we're on like our 5th one.
How long are you here for still?
We'll leave this afternoon.
Oh. You ever go to Zorene's in Palo Alto? How far are you from Palo Alto?
We are on the live feed. So I don't care if you don't care, but
I don't care, Judge.
Should have write it down.
Oh, it's the absolute best Indian food I've ever had.
Not a sponsor.
It's phenomenal.
Cool. We'll go.
Good Indian food.
Did you find it?
No, I'm not looking it up. I'm just writing.
No. Wow, it's good. Really, really good.
Great. How was California?
Very nice. Everything just couldn't have gone any smoother. They moved her into a different room, which is huge because the room they had her in before, the
Tyler, no problems.
Are right outside the window.
Hope that helps.
So starting at the minute it's daylight, it was beep, beep, backups. And so she's away from that. Everything just went about as smooth as it could go.
Awesome.
well, now we're all back to work. The fair's over, no vacations for a while.
Well,
although you've got several, so yes.
Anyway, well, it was nice seeing you. I'm glad you had a good time. You had all good weather.
They had great weather and they got everything they bid on at the fair.
Oh, is that right? So did you have to get a trailer?
They're you don't want to get in a bidding war with them.
You didn't need a tree stand, you just decided you wanted to win the bid. Got two deer hunting lines.
You didn't know you were bidding against him.
Yeah.
On those
I'll
items.
store those for you. Have a safe trip back. Thank you.
Want to go to the fair?
Judge Pattison likes to take his vacations in the fall, and I take mine in the summer, and that works out pretty good. He's got some nice trips coming. All right, it is 9:30. Attorney Jessica Kelly is here on behalf of Discover Bank. Good morning.
Oh, man, I'm not going to do a credit card one. I'm sorry. We're going to
We've had.
Oh, the one I
But
bailed
thank
to
you
was
for
just
being
quit.
here on time. The defendant is not here. Let me call the case once again. This is Discover
Summary
Bank
judgment.
versus Michael Robles. File number is 25748GC. Attorney Jessica Kelly is here on behalf of the plaintiff. This is a claim for $8,996.85 plus cost, interest, and attorney fees.
Just shy of 9,000.
Once the lawsuit was served on the defendant, he filed a written letter, which we accepted as an answer, expressing his current financial circumstance, which isn't great, and requesting a payment plan. Plaintiff has filed a motion for summary disposition under the theory that the defendant has not stated any defense, and there is no material issue of fact. As I often say, the fact that you don't have any money is not a defense to the fact that you owe the money. Although he had proposed a payment plan. Ms. Kelly, have you had any contact with this defendant?
I know that the firm had some contact with the defendant in middle of July, and some options were floated, but the parties weren't able to agree to anything. What Mr. Robles was proposing would have resulted in a payment plans that would have taken something like 30 years, and so it just wasn't something that we could, have the plaintiff agree to. So that's why we're here on this motion for summary disposition, because the amount owed isn't in dispute. It's how it'll be repaid, and we're certainly sympathetic to Mr. Robles' circumstances and happy to continue to look for repayment options that work for both parties.
All right.
Reverend Beasy on the
I'm
jury.
going to just grant the
21
motion
months.
for summary disposition. At this point, he's only 2 minutes late. Let me make sure he's not here.
Judge is going to call. Reverend Beasy, yeah, YouTube doesn't count very well.
I'm looking for a Michael Robles.
Where are we calling him at home?
All right, thank you. Bye. All right. Even if he were here, I would be inclined to grant the motion for summary disposition. And I'm going to grant it. When I've granted default, they have 21 days to move to set it aside. When I do the summary disposition, the rules are different. So I find there is no material issue of fact and no defense has been stated. I grant summary disposition on behalf of the plaintiff in the amount of $8,996.85, court cost of $152.29 for a total of $9,149.14.
Thank you, Judge. Is the prepared order in the court's files there, or is that something you'd like us to submit?
It is, and I greatly appreciate it. It makes it much more efficient. So I've signed the order that was provided. I'll put the amount down, $9,149.14. All right, I don't know how the rest of your Monday shakes out. I've got a few more of these to do, and then I've got some criminal sentences. Then I have great leftovers for lunch, so I've got my whole morning planned out. So
tell us more.
All right, I'll see you next time. But If he does appear, I'll indicate that I granted a motion for summary disposition. If he does not appear, he'll get it in the mail.
All right.
All right, thank you.
Now we jump.
Thank you, Judge.
Case. Your second option is to admit responsibility, but with an explanation
They're
that
getting
you
their
believe
instructions right now.
mitigates your circumstances. And your third option is to deny responsibility. That is your right and your privilege. If you deny responsibility, the court will swear both parties under oath. The officer testifies first. They have the burden of proof today. Then it's your turn to testify.
These are all people
Tell
Officer
this court what
Moran
you wish the court to know
ticketed.
about the incident. And then the court will make a finding of responsible or not responsible. That is based upon the civil burden of proof. Again, I remind you, we're in civil court. So it does not require a heavy burden of guilt beyond a reasonable doubt to be shown, but simply a preponderance of the evidence, otherwise known as the featherweight test. I would also suggest that if you have a documentary case involving insurance or registration documents, and you've updated those items, please have those handy for display this morning. I'm going to excuse you back to the waiting room. Be ready with your selection. Thank you.
Pop, 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 pop. Everyone goes back to the waiting room. Karen at 2. Karen at 2. Yeah, it doesn't start till then, so nothing to see yet. My local college football team got beat soundly Saturday night. I was going to tell you, I went up to Richmond. Went to Virginia yesterday. I was in Virginia. And stayed at a hotel up there last night. Drove back early yesterday morning. The three times I've been in Virginia, Richmond, Virginia, it has just dumped down buckets of water. Just tons. Oh, and I ran, because I'm out of state now, and you can't catch me. I ran a red light.
Calling case number 25, RO
No,
04849.
it wasn't like running a red light. I stopped, and then I turned right on red, and then I saw no red on red.
Roland Houston, that's you, sir?
Kirk Ronald Houston.
You are correct, sir. All right, we can see you've had your coffee. Mr. Houston, you were present earlier when the court explained the nature of an informal hearing. True?
True.
Yes.
And so you understood the court to instruct that you must select from one of three options to protect your rights, correct?
Yes.
Thank you, Mr. Houston. The citation before the court was issued July 25th. This year at 8:03 in the evening, you were operating a 2001 Chevrolet black and color northbound Woodward M1 at or near Normandy, City Royal Oak. And at that place and time, it was discovered that your vehicle plate had expired on your birthday this past April.
Come on his birthday. Oh.
You can admit responsibility, you can admit, explain, and display an updated registration, or you may deny responsibility and will swear the parties and take testimony. What do you wish the court to do?
Yeah, I will admit responsibility. I did get my plates renewed.
Okay, so as far as the factual record goes, you are confirming that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Yes, I was.
Do you have your registration handy? That is affirmative. Bring it down a little bit further and then move it over to.
They're showing.
Officer?
Magistrate, I can make it easy for us. I already checked it. Go ahead and motion that this thing get dismissed.
Terrific. All right, that one's gone, and you know what to do every April 7th. You're still a young guy, so
yes,
it's going to be your birthday and your registration day for the rest of your life. Take care.
Thank you.
Move out of state. Register somewhere else. Otherwise, you're going to be paying the government every time you have a birthday, and that's just going to suck. Yeah.
Court calls case number 25 RO 04865. This is People of the City of Royal Oak versus Joshua Philip Giancona. Thank you, sir. Thank you. Mr. Giancona, you were present just minutes ago when the court explained the nature of an informal hearing. True?
Yes, sir.
So you understood the court to instruct that you must select from one of three options to protect your rights, correct?
Yes, sir.
Thank you. Mr. Giancona, the citation for the court is a simple one. It indicates that on July 26th of this year at about 20 past 8 in the evening, you were operating a 2013 Suzuki, red in color, northbound on Woodward at a 13-mile road in the city of Royal Oak. And at that place and time, you exceeded the posted speed limit by a minimum of 1 to a maximum of 5 miles over. Officer Moran's
1 to 5, you
remark
pulled him over?
on your ticket indicates observed bike northbound Woodward near 13. He was running front radar, and your margin of speed was actually considerably larger than the 1 to 5 over. But regardless of all that, today's your day in court. Mr. Giancona, you can admit responsibility in this matter. You may admit and explain, or you can deny responsibility, and we'll swear the parties and take testimony. What do you wish the court to do for you?
No, I admit responsibility. The only reason why I called in this ticket was I was asking about insurance, if it was going to affect my insurance, and they made me a court date, but I admit responsibility.
Well, the court wants you to know it's not in a position here to accept a conditional plea. The court has to umpire these games fair and square to both sides. So the court's not here to negotiate with you. The court and the officer are from separate branches of government. What the court needs to do first by court rule is take a plea, and then any sanctions that are forthcoming are certainly a different matter. And obviously the officer's input weighs into that as well. But I need to know if you wish to contest this ticket by us taking testimony today, or if you wish to admit responsibility.
Admit responsibility.
Thank you. So you were driving a motor vehicle in the city of Royal Oak, that place and time, and exceeded the posted speed limit by at least 1 mile over, correct?
Yes, sir.
Thank you. Mr. Giancona.
I'm guessing it was more than 15.
How long have you been riding?
Probably about 6 years, 7 years.
All right. So you know, head's on a swivel and you're riding on a gum wrapper, right?
Yeah, I actually sold my bike since that incident. That was my first time riding in Royal Oak, and I didn't know how crazy it was out there. Got in a situation that day, and my bike has been sold since then.
Okay. You have children?
Yeah, 3 kids.
Okay. I see that from time to time with the motorcycle folks. They'll have a second thought about things. I appreciate your candor, officer. Anything on your behalf?
Magistrate, can you check his driving record for me, please?
Sure could.
Oh, Thompson.
So the record should reflect that for the very first time today or any other day, the court is taking a look at Mr. Giancona's record.
Are you nervous?
The last citation he received was 5 years ago for limited access speed in New Baltimore.
Magistrate, motion to take it amended to impeding.
Okay, this will be amended to impeding with your
What a good-
permission, Mr.
what a good
Giancona. Is that
officer.
acceptable to you?
Yes, sir. Thank
All
you,
right,
guys.
so impeding traffic is a 0-point violation, will not mar your master driving record. So the motion to amend to impeding is granted. The fine is $175. That is payable through the pay portal on the court's website, or you can walk a cash ticket charge into the 44th District Court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days.
Pay it in pennies.
I know that they're a lot of fun, but maybe a good move selling the bike. Take care.
Yeah. Thank you.
They amend it to impeding pretty quickly. When Judge Simpson amends a ticket down, the process is a little bit more lengthy.
Oh yeah, they belong to me.
Hello, ma'am. How you doing?
Thank you.
Or what did you do, I should ask. Caitlin DeGrove.
Calling case number 25, RO04634. This is people of the city of Royal Oak versus Caitlin Marie DeGrove. That's you?
Fight it.
That's me.
Fight it.
Mr. Grove, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court to instruct that you must select from one of 3 options to protect your rights, correct?
Yes.
Thank you. Mr. Grove, the citation before the court was issued on July the 16th of this year at about 20 past 7 in the evening. You were operating a 2017 Chevrolet, blue in color, southbound Washington, at near Kenilworth, City of Royal Oak. And at that place and time, you exceeded the posted speed limit by a minimum of 1 to a maximum of 5 miles over. Officer Moran's remark, which appears on your ticket, indicates southbound Washington, Kenilworth. Margin of speed appears to have been, according to radar, 16 miles over, but he wrote this for 1 to 5. And regardless, today's your day in court. You may admit responsibility in this matter. You can admit and explain, or you can deny responsibility. We will swear the parties and take testimony. What do you wish the court to do for you?
Admit and explain.
Very well. So you are confirming that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by at least 1 mile over, correct?
Yep.
Thank you. What's going on, Mr. Grove? What do you want the court to know?
I just didn't know I was going that fast, and I didn't really realize that the speed limit was 25 at that area. Not from the area, but I'll know in the future when I go.
So you're out in Commerce?
Yes.
Okay. Things tend to run that's a little more, well, it used to be rural, but things run a little more speedily out there, M59.
Yes.
And, okay, I get you. Do you have any idea what your driving record looks like?
It's clean. I was in an accident a few years ago. Didn't get a ticket for it, but other than that, nothing.
All right. Officer, what would you like to share?
Yes, magistrate, go ahead and motion ticket amend to impeding.
All right. There's a motion to amend to impeding traffic. That's a 0-point violation. Will not mar your master driving record. Is that acceptable to you?
I'll take it.
All right. Impeding traffic. The sanction is $175. That is payable through the pay portal on the court's website, or you can walk the cash check or charge into this court. 400 East 11 Mile Road, Monday.
What's the fine for speeding?
8:30 and 4:30. And that's going to be due within 14 days. Good luck to you.
Okay, sounds good. Thank you.
What's the fine for speeding? Is it like more financially beneficial to the court to have impeding or 1 to 5 speeding? It does look like a money.
Is there a Declan Sabga available?
Yep, I'm here.
Hey,
Sir,
Declan,
are you
welcome.
here on a private property parking citation?
Yes.
Okay.
What?
This
Private
is case
property?
number M, like Michigan 026098. It is people of the city of Royal Oak versus Declan Sabga. Am I pronouncing that correctly?
Yeah, that's correct.
All right, Mr. Sabga, the citation before the court, you were present earlier when the court explained this procedure this morning, correct?
Parked in like somebody else's
So you
stall.
understood the court to instruct that you must select from one of 3 options to protect your rights, correct?
Yes, correct.
Mr. Sabga, the citation before the court was issued July 26th of this year at approximately 20 past 9. A BMW plated to you or a member of your household, an Ontario plate, was parked on private property without permission, to wit, at Taco Brothers.
Yes.
So the citation is obviously non-moving, 0 points. It is a private property parking citation. You may admit responsibility. You can admit and explain.
Explain,
or
please.
you can deny responsibility, and we will swear parties and take proofs. What would you like the court to do for you?
I'm gonna admit responsibility.
Very
come
well.
on.
So you're admitting to the court that on the date in question, you were operating a motor
say you were
vehicle
getting a
in
taco.
the- Strike that. A vehicle plated to you or a member of your household was parked or stationary at Taco Brothers without permission from the owner, correct?
Yes, correct.
All right, court accepts your plea. Thank you so much. Any input from the people?
Nothing from me, magistrate.
All right, Mr. Moran.
He was doing this to avoid paying the parking fee. I
Mr.
think.
Savga, what the court's going to do is treat this as if it was overtime at meter. So the court's going to reduce that citation from the normal rate to $20. That is payable through the pay portal on the court's website, or you can walk a cash check or charge into this court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. And that is due within 14 days. Good luck to you.
Okay, thank you, Your Honor.
$20. Don't park there at the taco place.
I still don't know where Taco Brothers is.
Me either.
No.
Maybe you should go there for lunch.
just north of Normandy on Woodward.
Gentleman has some very acute hearing.
Akash is here with headphones so he can hear.
Thank you. This is case number 25, RO04521, people of the City Royal Oak versus Akash Kaluri. That's you?
That's me.
All right, Mr. Kaluri, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yep.
So
Yes,
you
yes.
understand.
Yep.
So you understood the court to instruct that you must select from one of three options protecting your rights, correct?
Correct.
Mr. Kaluri, the citation before the court was issued on July 11th this year at 20 minutes of 8. You were operating a 2017 Subaru Forester black in color on Washington Avenue and near Harrison in the city of Royal Oak, and you exceeded the posted speed limit by a minimum of 1 to a maximum of 5 miles over. Officer Moran's remark, which appears on your ticket, indicates a margin of speed of 15 per radar, but that citation was only written for 1 to 5 over. Regardless, today is your date in court. You may admit responsibility in this matter, you can admit and explain, or you can deny responsibility, will swear parties and take testimony. What do you wish the court to do for you?
I would like to admit and explain, so that's second option.
Oh, goody.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed limit by at least 1 mile over, correct?
Correct.
Court accepts your plea. What do you wish the court to know?
Just to be, first off, I just want to say that I'm extremely sorry for this. That was, obvious. What I'll say is that I spent the last few years living in Washington, D.C. I didn't own a car at the time. I wasn't driving. This was my first month back in Michigan and back in town, and sort of getting back into the swing of things. It was a humbling thing to get the ticket. I've been a pedestrian for most of those last few years in DC, and so that sense of that kind of like realization, like, okay, I'm on the other side. You have to be more vigilant, and so I've been more I've been more conscientious ever since. And so I would just ask for some clemency in that regard. If there's anything I can do, any kind of course I can take, just because it was kind of the first time, and I promise it won't happen again.
Thank you very much, Mr. Kaluri. The court appreciates all your remarks and believes they are made in good faith. Officer Moran, what would you like to share?
Magistrate, motion ticket get amended to impeding.
Okay, impeding traffic, Mr. Kaluri, is a 0-point violation. Will never appear on a master driving record. That's acceptable to you?
Yes, I appreciate that.
Very well. So the
I wonder if insurance
original
companies watch
citation
this.
will subsume plea to impeding traffic. The fine is $175. That is payable through the pay portal on the 44th District Court website. Or you may walk a cash check or charge into the 44th District Court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. Are you comfortable telling the court what you were doing in the Beltway? Because it sounds important.
I was working on democracy and human rights work in DC for the last few years. Yeah.
All right. Good for you. Thank you for your service. You take care now.
Thank you. Take care. Bye.
He wasn't speeding, he was flying low. I think we're almost done. We've got a couple more here. We need one to fight. Fight the ticket.
Calling case number 25, RO04527. This is people of the City of Royal Oak versus Latasha Renee Voss. That's you?
Yes. Sorry. Yes, Your Honor.
Fine. Ms. Voss, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yes.
And you understood the court to instruct that you must select from one of three options to protect your rights, correct?
Yes.
Thank you, Ms. Voss. the court wants to make as plain as possible all the parts here, because this is slightly more exotic due to the fact that it was written as what we call a lesser included. So
Yes.
this ticket states that on July 11th of this year at 11:05 in the evening, you were operating a 2017 Infiniti white in color. Now, under the remarks section of your ticket, what Officer Moran indicates is that subject northbound Maine around 5th and made a U-turn to southbound Maine from the
Yes.
right curb lane. So what he witnessed could be written as improper lane usage, improper turn, even careless driving. But what he did do that evening is write this for impeding traffic, which is a 0-point violation and does not mar a master driving record. Regardless of that, Ms. Voss, today is your day in court. So if you wish, you can contest this ticket. So the court needs to understand, do you wish to admit responsibility in this matter, admit and explain, or do you wish to deny responsibility and we'll swear parties and take testimony?
I wish to admit and explain.
Very well. So you're admitting to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak, and at that place and time, in some form or fashion, you impeded traffic, correct?
Correct.
Thank you. Court appreciates your honesty. What would you like the court to know?
So what I wanted to say, oh, and good morning to the officer as well. What I want to say, the officer was actually behind me. I didn't see a sign that you couldn't make a U-turn. It was dark, so I did go back to that area like a few days later when it was daylight outside, and I still didn't see a sign, and I would never had to turn because the officer was right behind me. I would even, I would never had to make that illegal turn that I did right there, but I didn't see the sign, so I wanted to say that. And then when, like I said, when I went back in the daytime, I still didn't see the sign. And then the other thing I wanted to say, far as the payment, if it could be reduced or if I can have time to pay it, if it couldn't be dropped, because I was recently injured from work and I was off work, and I recently just returned back to work.
Okay. Court understands your challenges. Thank you, Ms. Voss. Officer Moran, any brief and helpful hints related to U-turns?
I do know that that they are posted on all up and down Main Street, but we'll make it super simple. I'm actually going to dismiss this ticket, Magistrate.
Oh, all right. This ticket is going to be dismissed.
Whoa.
Apparently, you're doing everything right.
You won.
Post the evening in question. So, ticket is dismissed. Welcome back to work. Take care of yourself. Good luck to you.
Thank you so much, Your Honor. Thank you so much to the officer as well.
It's a rare win. Officer's like, yeah, that sign might be missing. So maybe it wasn't illegal.
Calling case number 25 RO 04522, people of the city of Royal Oak versus Jordan Conrad Dowidzenka.
Yes.
Mr. Dowidzenka,
he's happy to be here.
You were present earlier today when the court explained the nature of an informal hearing. True?
True.
So you also understood the court to instruct that you must select from one of three options to protect your rights, correct?
Correct.
Mr. Dowidzenka, the citation before the court was issued on July 11th this year at about 10 minutes of 8 in the evening. You were operating a 2022 Hyundai white in color on Washington Avenue at or near Harrison in the city of Royal Oak. And at that place and time, you exceeded the posted speed by a minimum of 1 to a maximum of 5 over. Now that's the citation as written. Officer Moran's detail note indicates a margin of speed of 15 over the posted speed of 25. But
sounds like 15
regardless,
is the limit. That's where they get
today
you.
is your day in court. So as to 1 to 5 over, you may admit responsibility in this matter. You can admit and explain, or you can deny responsibility. The court will swear the parties, and we will take testimony. What do you wish the court to do for you?
I will admit responsibility.
Very well. So you're admitting to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. And at that place and time, you exceeded the posted speed limit by at least 1 mile over, correct?
Correct.
Thank you, Mr. Dowidzenka. Anything you wish the court to know related to that?
I just more or less wanted to show up and see if the court was open to helping me keep my record clean. If that was at all an option.
It's actually something you could do.
That's
with
a
the gas
tricky
pedal.
street, and since then I've gotten a bunch of my friends to even watch their speed on that street because a lot of people were unaware that that spot is like that.
trap.
So this was a nice little wake up call. So I've gotten a lot of other people informed and more or less just wanted to see if there was a way to admit responsibility and see if I could reduce the charge at all. But
You
yeah.
can't reduce it, but they
Okay.
can.
Court appreciates your remarks. Officer, what would you like to share?
Check his driving record for me, please.
Of course.
Ooh, let's see. Boom, boom, boom.
All right, the court is taking a look at Mr. Dawoodzinka's driving record for the very first time. And the last citation he received was actually issued on July 4th. Limited access speed in Standish, which certainly sounds like a July 4th weekend Interstate 75 circumstance. And that's all there is.
Magistrate, motion to give amended impeding.
All right, there's a motion to amend to impeding traffic, Mr. Dawoodzinka. That is a 0-point violation, will not permanently mar your driving record. That's acceptable to you?
Yes, thank you so much, officer, and your honor.
All right, so the original plea to speeding subsumes a plea to impeding.
Speeding, impeding, they rhyme at least.
Fine is $175. That is payable through the pay portal on the 44th District Court website, or you can walk a check or charge into the 44th District Court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. And that is due within 14 days. Please watch your speed.
Yes. Sorry, how do I pay that?
Cash to me.
You can pay it over the pay portal on the court's website.
Okay.
So just using your Google machine, or you can certainly visit us here at 400 East 11 Mile Road between 8:30 and 4:30, 5 days a week.
All right. Thank you so much.
Take care.
You too.
I think we're going to be going to Tennessee here in just a minute.
Yeah. Samantha Harvey never showed up. Okay. I think that might be a sweep for you, Officer Moran.
That sounds like it is for me as well. All I had was Samantha Harvey and she didn't show up. Magistrate, thank you.
You bet. Take care. We should see Officer Blitz
here
around.
for his- Yeah, Officer Blitz is here.
All right. Thank you.
Thank you, Magistrate.
Is that microphone on, please? Check that microphone and make sure it's on.
Is
that better?
That's better. Thank you.
All right. Shonda Carver, page 8 of your docket. It's Carver.
Who is this?
Shonda Carver.
Okay.
Your Honor, on this matter, or on these two matters, I'm still waiting on some discovery items from the state, so I'd ask for one more status date.
State have any position on this?
I've never seen this courtroom so full.
Judge, I agree with her statement. Judge, I agree with her statement.
It's standing room only there.
The next status date would be January the 7th. And that will be the last status date. It will be set for trial after that date if you don't resolve it. So
Thank you, Your
what I
Honor.
want you to understand, Ms. Carver, is that that January 7th date is your last opportunity to resolve your case by an agreement. On that day, if you have not reached an agreement, I will set a trial date. And on that, you'll then have to either go to trial or plead to the indictment or go to sentencing. All right? Thank you. Stay in touch with your lawyer. Ms. Wilkerson, what's your next case?
My next case is.
Ms. Carver, you may leave.
You're done. 1-7. Page 9 of your docket, Jamie Clark.
Jamie Clark.
Okay. Your Honor, I think on this matter, we need a motion date and then, do you want to set it for trial now?
Yes.
And the trial date?
You need a motion date and a trial date?
Yes, Your Honor, this is the daycare case that was transferred from Stewart County. There are probably about 4 to 6 forensic interviews that we'll need a motion day on involving children. And then the trial, I would expect to be a multi-day trial, given the number of victims.
Any reason we can't hear the motions in Stewart County?
I'd be fine with that.
Yes,
I
that'd
mean,
be fine.
it's been transferred, the venue's been transferred to here. But it would appear to me that witnesses and everything are located in Stewart County, and I'm gonna be in Stewart County in December. And that would make the most sense to me to, because I don't have another status date or motion day in this court unless it's this VOP day later this month.
Let's do, December, I hadn't thought about that.
All right, we'll put it on December the 8th for all motions. You see any reason we can't do that?
Your Honor, I'm in a final hearing in another county.
I'm sorry?
I'm in a final hearing in another county on that day.
Well, that presents a problem.
Yes, it does.
Because I don't have another date to give you.
I was gonna ask Your Honor if we could do the motions, if we were gonna go here in January, or if we have another day, a
Well, we
special
can
day
do
in
that.
December. And then set maybe a May trial.
Calendaring, one of the trickiest parts of court.
All right, so we'll be talking about motions in January.
Either he's got a ton of stuff to do today, or
how long
community's very
realistically do we
invested
think
in one
the
of these
motions are gonna
cases.
take?
Well, it's the same forensic interviewer, so we won't have to have it in. Probably
Most of a day?
And I'll
You get too many more people in there, you're going to have to call the fire
January
marshal.
the 9th?
Yes, sir, that works.
Maybe one of you men could stand up and let the pregnant lady have a seat.
Yes.
Just saying.
With somebody here to support them, wait out in the waiting area.
These are the people who are here to support somebody. We evicted a few people.
How long do you think realistically it'll take to try it?
I would say at least 4 days.
How many?
4.
4 days.
He doesn't have 4 days anywhere. Schedule's so tight. It does sound like this is one of those
It's
cases
like you're
we would
going to be
not
in
follow.
June.
Holy smokes.
June 15th through the 18th would be the...
Your Honor, I'm getting married, and that's my honeymoon.
We'll be happy to let you and your new spouse come in and y'all can...
I don't
You
think
can
he would be.
canoodle out in the waiting room area. So.
I don't think he'd be too happy with that.
July 20th, 21st, 22nd, and 23rd.
Yes, Your Honor.
Thank you.
This will be the trial date for the daycare case involving multiple defendants.
Daycare case.
Your Honor, page
Multiple
15,
defendants.
Dantes Good.
Give me a moment to make
Yes, Your
this
Honor.
notation on my calendar. What is your client's name in that particular case is Jamie Clark, right?
Jamie Clark.
Katie, I think they resolved that one
All right,
outside
I'm sorry,
of
what
court.
was the next one?
Page 15, Dante's Good, and I actually have Mr. Good.
Mr. Good. Mr. Good.
On page 15. He is in the Department of Corrections in Bledsoe County.
Yes, Your Honor. And I was given an offer.
Is this the
there-
one you were talking to me about? General?
Yes, a date between now and trial. I understand trial's not going to move, but
Judge, this is an issue where obviously the offer that I sent must have gotten lost in the mail, so I don't have an opposition to us trying to find a date.
We're going to give you another status date, but once you have reviewed that, if you need a date for a
offer got
plea,
lost
then
in
you
the
can
mail.
get with General Wojnarowski. She'll get with my assistant, and we'll get you a trial. We'll get you a date. It'll be out of county, but we'll let you take care of it. But the trial date's already been set in January, correct?
yes, Your Honor.
So I don't have another day other than the 29th of this month.
And that's
to,
fine, Judge. I'm happy to go out of county if he decides he wants to enter a plea.
Okay, yes. So I'll just set if he wants to.
They're just talking away from the microphone so you guys can't hear everybody. But lady with the red shirt and the blue jacket is really, really quiet.
You set that one on
KK, yes, in the
We've
afternoon.
already set something, I might be able to do it on October the 29th in the morning at 8:30 if General Wojnarowski's aware of that. If it works out for that, we can do it on that day as
I'm
well.
fine with that too, Judge.
So 10/29.
Maybe we do follow
October
that case.
29th.
At 8:30.
July. 4 days in July.
But I'll figure it out.
Nap time was extremely
We'll figure
peaceful
it
in
out.
that daycare.
And then the
but
last thing I have, Your
without
Honor, page
parental
11, Derek
permission.
Dillard. I actually withdrew from that case. And I guess he's been picked up, and you can reappoint me if you'd like. My name's on the docket. I just wanted to,
You withdrew from the case, but you're still on the docket, so you're saying you want to be appointed?
I mean, want is a strong word,
That's
but
that
I'm
is-
willing to be.
You're willing to be appointed?
Why did
Yes.
you withdraw
We'll
last time?
appoint you to represent Mr. Dillard.
Okay, what's the next date then for him?
There's a status date today, so your next status will be that January 7th date, and then we'll set a trial date after that.
All right, sounds good. Thank you. That's all I have. Thank you, Your
All right,
Honor.
Thank you. Ms. Lewis, I will call the docket unless you want to do it.
Super T. Oh, man.
That's, well, in my opinion, it's the final plea day. So. 2024 CR 138, State of Tennessee versus Ashton Ryan Algard. Mr. Potter.
Your Honor, that's a serious case. I've talked to General Wojnarowski, and she says that there's additional DNA testing being done by the TBI that I do not have yet. In addition to that,
He's a clicker.
we're probably going to need some motion dates at some point in time. I just would ask at this point in time to reset it, please, to the next status date on January 7th, if that's available.
January 7th, General? If you need motion days, you need to get with my office and see if you can get those arranged.
We'll see what we can do. Thank you, Judge.
All right. 2024 CR 83, State versus Cody James Albier, public defender. This is in jail. Do we need to bring him online, or do we don't have the jail, I don't think. He's on the bring down? All right, we'll put him on the second call.
Yes, sir.
Moving to page 2, 2024 CR 90, State versus, well, I'm sorry, that's the same defendant. I apologize. 2025 CR 44, State versus Jason Anderson Allen. We need to bring that person down, or can we do it by Zoom? Okay. So is Mr. Albu back there? Bring out Mr. Albu if he's, we've got him here. Let's go ahead and bring him out. He says we don't have any. All right.
We got nobody here?
We'll put them on. We'll come back to them. Let me know when they're here, please.
Bring them from the jail.
I'm going to move down to those that are not in custody. Page 3, 2023 CR 21, State versus Gary Ray Baker Jr. Mr. Scruggs.
We have reached a settlement in that case, and I was advised that a different judge could actually hear the plea. We'd like to have it heard, plea entered on October 20th, and he'll go into custody at that time.
All right,
That's a guilty
so
plea.
You said you have another judge that's advised you they would take the plea?
Actually, I was advised by your office
All
of
right.
that.
And that set it for the 20th of October?
Yes.
October 20th for a plea.
Thank you, Judge. Appreciate it.
2012 CR 92, State versus Melissa Ann Barnes is in jail. We'll come back to it. 2025 CR 101 on page 5, State versus Jernisha Marquita Birdsong for arraignment. Jernisha Marquita Birdsong. Do we have a bond on her? I'll put her on the second call. 2023 CR 192, State versus James Edward Boyd, Public Defender.
Yes, sir. This is a status on Mr. Boyd's case. As far as we know, he's still receiving hospice care. We received a letter from the oncology treatment providers saying that he had ended treatment with them, and I believe we had spoken with Your Honor's assistant by email regarding Mr. Boyd's presence today, that it could be excused.
Judge, it is the state's request that his presence be excused and that we reset it for a January 7th status.
All right, January 7th.
Thank you, Your Honor.
2025 CR 124, State versus Stephen Garrett Brea. Sorry. Come up, please. Mr. Brea, you are here to be arraigned on an indictment charging you with aggravated domestic assault and with domestic assault. You have the right to an attorney. Do you wish to have a lawyer?
Yes, Your Honor, please.
Have you hired a lawyer?
No, Your Honor, I just had surgery. I'm about to have an ankle replacement in the next 2 weeks. I haven't been working. I've been laid off since my injury.
All right, raise your right hand. Let's place you under oath.
Ankle replacement. That's a big one.
Yes.
We're going to have you fill out what's called an affidavit of your income and expenses for me to determine whether or not you are eligible to have an attorney appointed for you. If you have other assets that would allow you to hire a lawyer, then you would not be eligible. So we'll let you fill this out, and I'll come back to you later in the day.
Yes, Your Honor.
And make sure you list your Bitcoin. All your IBM stock and everything.
And I'm moving through these cases that are not in jail until we get the inmates down here. 2022 CR 323, State versus Sonia M. Cervantes Mendez.
Usually
Mr.
you
Potter?
cut off the monitor, not the ankle, but, to each their own.
Mendez is my client, Your Honor. We're going to just need a trial date for that case.
You need a trial date?
Yes, sir.
All right.
1 day.
January 16th.
Yes, sir. Thank you.
All right.
Separate trial. I'll be in touch with you.
Twenty 109, State versus Kristen Clark. Mr. Lockhart. This is, all right, so we need a trial date for it. Once we go past today, it'll be go to trial or plead to the indictment and to every count of the indictment to go to sentencing, but a trial date.
Your Honor, this is a co-defendant on the daycare case, so we can use the same dates.
All right.
January 9th for
They're being
motions,
tried separately.
then
It's the daycare case.
July the 20th through the 23rd is what we have scheduled. So.
Oh, they're being tried together then. Co-defendant.
I represent her husband, Ethan Pulley, who's on the docket also.
What's his name?
Ethan Pulley. Same thing, it'll be for trial.
All right, then we'll set it on the same day.
Thank you, Your Honor.
Thank you.
So 3 co-defendants in that case. I'm sure this is going to be a televised case. It's only 4 days long.
2023 CR 178, State versus Randall L. Clark.
There are 4 of them. There might be another one.
Your Honor, on this case, there's a court-ordered evaluation for Mr. Clark at MTMHI. That has not yet occurred. We'd like to try to get that rescheduled and are asking for another status date, please.
January 7th, 2026.
Thank you, Your Honor.
Clark, you need to make sure you cooperate with this evaluation. Follow your
I have
attorney.
one right here.
Okay, well, you show that to your lawyer.
I did.
He'll let me know if there's anything I need to do with it.
I did.
Thank you, Your Honor.
All right.
Judge, I would ask that he be ordered to attend that evaluation when it is
As a
scheduled.
condition of his bond, he'll be ordered to attend that evaluation. So make sure he understands that.
Yes, sir.
2025 CR 192, State versus Cody Allen Corbin for arraignment. Cody Allen Corbin for arraignment. Step outside and see if there's anyone named Cody Allen Corbin. Mr. Corbin, you're here to be arraigned on a charge of theft of property between $10,000 and $60,000. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes.
Are you planning on hiring a lawyer since you're on bond?
I'd like to get one appointed if possible.
Well, raise your right hand. Let's place you under oath.
Yes.
You're going to need to fill out this form for affidavit and indigence of income and expenses for me to determine whether you qualify. It's not an automatic thing that you can have an attorney appointed. Only if I determine that you are indigent can you get an attorney appointed. So when you sign this, you're signing it under oath, so make sure it's accurate. I'll come back to you later in the day.
All right.
Twenty 2025 CR 19, State versus Nicholas Harden Creech. Mr. Creech, today we're supposed to advise us who you have hired as a lawyer.
Your Honor, the IRS has got my tax check held up, which is I was counting on for the retainer fee, and they're telling me it's gonna be about 6 more weeks on that for amended return. I need a little more time to get it together.
I'm going to set you for January 7th, and you
The
need to hire
IRS
your
has
lawyer
my
and have that lawyer
refund
there
tied
on
up.
that day, because your opportunity to resolve this case by an agreement is going to be determined on that day whether or not you have complied with the court's instructions regarding hiring a lawyer.
Okay.
January 7th.
Thank you.
2023 CR 229 State versus Ted Bradley Davenport. Mr. Vandervoort. Good morning.
In case that Mr. Wainick has, we've been unable to resolve it, so I guess we just need a trial date.
How long do you think it'll take to try it?
Judge, I was actually just speaking to Mr. Lockhart, who represents the victim in this case in his pending matters in Cheatham. The victim has currently been deemed incompetent.
That's a dismissal.
I'd like to talk to Mr. Vandervoort and Mr. Wainick. I talked to Mr. Wainick some about going to trial without the victim, and he wasn't okay with that. But if we could get, I don't mind setting it a trial date, Judge, but I need a status date between now and then, because I'm not quite ready to say there's no possibility of settlement.
I think the
It's been going on for
defendant,
some time, Your Honor, and we filed our motion for speedy trial.
they want a speedy trial. If the victim, I don't know what
All
kind
right,
of case
January
this is.
16th, and we'll set the new status date for January 7th.
Thank you, Your Honor. Judge, that's all I have.
All right, thank you.
If the victim is incompetent, the victim would not be able to testify. Makes it very difficult to proceed.
2023 CR 328 State versus Caleb Dwayne Dawson, public defender.
Mr. Dawson?
Your Honor, on that, Mr. Dawson is participating in DC4 in Davidson County. He continues to participate in that treatment program. He's been promoted to phase 2 of that program, which is a 12-month phase, Your Honor. And based on that, we would ask that the court set a status in this matter in January.
General Bryson, you have any objection to resetting the status date for January 7th?
No, Judge, I'm in agreement.
All right, January 7th.
Thank you, Your Honor.
Moving to page 12, 2025 CR 85 State versus Amanda Wyatt Edmondson. Ms. Edmondson, you are here to be arraigned on a charge of theft of property from $2,500 to $10,000.
Oh.
You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Are you planning on hiring a lawyer of your own?
See if I can get one appointed, sir.
Raise your right hand. Let's place you under oath.
Yes.
You'll be filling out an income and expenses form that I have to determine whether or not you qualify for an attorney. It is not an automatic thing, and you must show that you're indigent. And I'll come back to you later in the day. You're signing it under oath, so make sure it's accurate.
Yes, sir.
2022 CR 359 State versus Shannon Antoine Edmondson. Mr. Atchison.
Morning, Judge.
Good morning.
We can't hear you. The sign language isn't helping. Microphone, please. Heard resolved.
So what are we doing with Mr. Hogan's case? Is he on the
We let the guy at the mic talk.
Yeah.
Judge is getting a headache already.
What do we do with Mr. Edmondson in the meantime? So, you have any opposition on it?
I mean, somewhat opposition to it, Judge, but I mean, I do agree with General Wojciechowski. I mean, we are trying to settle this matter with Mr. Edmondson. He's showed up at every court date, just like he's supposed to. So
All right,
I mean, as long as
January
it's tracking.
7th. We'll put it for January 7th. Thank you.
Thank you, Judge. Yeah. Your Honor, if I may, there was one that was passed up when you were calling the docket on page 12, Curtis Dudley. It's just an arraignment,
Give me
Your
a
Honor,
second.
for a
Let me get it
VOP.
fixed.
And I did file a waiver for Mr. Dudley.
I think that's a case that that's Mr. Dudley is a former client of mine when I was in private practice.
He
years
is,
ago.
Judge. I was just going to ask, based on the waiver and based on the underlying case in general sessions, which is set for October the 23rd, if I could just get a VOP date in October to resolve all matters.
Set it on October 23rd. That's in front of Judge Wallace. Is that correct? All right.
And correct. He does have to be arraigned on it.
Show that Mr. Dudley's been arraigned and a plea of not guilty is entered, and Mr. Atchison is the attorney. Set it for that October date.
Thank you, Judge. Seventh. Okay. Correct that.
Anything else, Mr. Atchison?
If the court would allow it, Judge, I have to be in Houston County at 1 o'clock for motion hearings. I believe the rest of mine are just announcement based. I could run through those real quick.
All right. How fast can you talk?
Pretty fast, Judge. Page 23 of your Honor's docket. Lacey Jordan Lackey. Judge, this is General Bryson's case, and I believe Mr. Talbot has the co-defendant in this matter. And Judge, we're all awaiting DCS records, and I believe that we can resolve this matter. We just need a little bit more time in terms of working out that settlement.
Yes, Judge, January 7th, please.
You want to put it on January 7th? All right, January 7th. What else?
Next. Judge, on page 26 of your Honor's docket, Jamie Mayberry. That's General Wojciechowski's case. And Judge, we have been talking about this case. She's had some language barrier issues with the victim in this matter. I do believe this case will also settle if we could just have another status date on Miss Mayberry.
Speaks what?
I think that's right.
Hindi.
Man, she needs to get to the mic. We
All
can't
right, so
hear
you
you.
want to put it on January 7th?
Or maybe just
Judge, on this one, and if General Wojciechowski can correct me if I'm wrong, but if we do eclipse that barrier that we do have prior to January, is that an issue where we could notify the court and possibly settle that prior to January?
Yeah, I mean, is this a trick question?
It's not,
If-
Judge.
If you're asking me if a case where I'm re-rolling all these to January 7th, you're asking me if you resolve yours before January 7th, can you take care of it?
Absolutely.
Absolutely.
Yay. All right, thank you. And the last but not least, I didn't touch the. Judge, I had.
I just want you to make sure, I don't have a possessory interest in these cases.
Well,
They don't
you
pay
know,
me.
I like to ask on the front end just to make
I
sure.
appreciate that, and there are
Absolutely.
certain cases I have to hear because of the nature of the fact that we've had pretrial conferences, but other than that, if you get your case worked out and you need to get it in court in front of a different judge, go for it, so.
Thank you, Judge. Last one I have, Your Honor, is James Travis Raymer. And I'm lost on the page number on that one.
2032.
All right. Judge, this is an issue where I had filed a motion on behalf of Bullseye Bail Bonds. This is him.
Yeah.
All right. So, Judge, a capias was issued, and I had filed a motion for an extension that was granted. In the meantime, he was picked up on that capias, and a new bond was set, arguably higher than the original $2,000 bond. He made that $15,000 bond prior to Bullseye being able to file anything while he was incarcerated. So, Judge, it'd be my position that that underlying bond would now be disposed of and replaced with the new.
Mr. Raymer, you're here on a $15,000 bond that you made after your initial bond was revoked. Bullseye Bonding will be relieved and discharged from their obligations on the underlying bond since it was a conditional forfeiture. So.
And Judge, I have an order to pass up for that one.
All right, Mr. Raymer is here. Has he been arraigned?
I think he's.
Mr. Raymer, have you hired a lawyer?
No, sir, I have not. I need time to hire a lawyer.
You need time to hire one? Well, you've made a $15,000 bond on this revocation or the revocation of your initial bond, so I'm going to put you for this. Is this a case that we can put on one of the other judges' dockets?
I think it's a DUI.
Okay. Let's put it on Judge Wallace's criminal docket call day. What day would that be? October the 20th is your next day to come back into court and let Judge Wallace know who you've hired so that Judge Wallace can sign you a trial date, okay?
Yes, sir.
October 20th. Make sure you hire one between now and then.
Yes, sir.
All right, thank you. Pardon?
Can I get a card?
See the clerk over here and she can give you one. We got a card we can give him, Missy. Okay. What else, Mr. Atchison?
Judge, that concludes my business. I hope that was fast
Drive
enough.
safely to my home county, so. All right. We'll go back then to call of the docket. 2023 CR 21, State versus Amriera Kokid Foster. Good morning.
Marie, I believe, is one, and then the other sister. We have an agreed order to continue that and waive their appearance today, Your Honor.
These are part of those cases that are set for trial in January, correct?
Yes, Judge.
We'll be here in January for trial.
I wish you'd stand at the microphone.
So do we need to do anything about another status date or just show it's for trial on the January 20th?
There's a whole bunch of cases in January, and then this wasn't daycare. Daycare's in July, right? Can't hear a dang thing.
All right, so we just leave it set for the January 20th date. All right. Remain set for January 20th.
Thank you, Your Honor.
2025 CR 87, State of Tennessee versus Jamarian LaShawn Fikes. Mr. Finley. This is for status.
Have Mr. Fikes in General Sessions Court. I think we
Judge, I think he was arraigned the prior term in front of one of the previous judges, so it was set on your docket for you to give it a status date. Judge, I'm awaiting certified copies of his new charges and will be filing a motion to revoke as soon as I get those.
So the question becomes when, I mean, it's here for status today. When do we, what are you asking, Mr. Finley, to set another status?
Good.
All right, I'll set a status date of January the 7th, but that'll be the final status date. But if in fact the state files a motion to revoke, then that needs to be heard. It can be heard by any judge. It doesn't have to be heard by me. So if you file that motion, we can hear it on the VOP day if necessary. That would be the 29th of this month. Otherwise, it'll be January the 7th for status.
Thank you, Judge.
All right, thank you. 2023 CR 46 State versus Pedro Garcia. Mr. Garcia, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer?
Yes.
Lawyer.
Pardon?
I have a lawyer.
You don't, do you want a lawyer?
Yeah.
All right, are
We've
you
got
able
his
to
picture
hire a
there.
lawyer? All right, you can hire a lawyer.
No, I know kinda, I know how a lawyer. Need a.
All right, where is the interpreter?
It looks like we got the right guy.
Let's have an interpreter come up.
His picture's on the paperwork.
Let's swear our interpreter in so that we can make sure we're on the record.
Most of them are waiting, yes. A couple are there to support somebody else, but they were out in the hallway. They were told to leave. It was full house this morning. Court just has a standby Spanish to English translation available. Interpretation, sorry.
All right, Mr. Garcia is charged here with violation of probation.
Usted está cargando por una violación de probación. Yes.
And the question becomes, does he wish to have a lawyer represent him?
Y la pregunta es si usted quiere un abogado que lo represente a usted. Yes.
Is he able to hire an attorney of his own choice?
Usted tiene la capacidad de poder contratar un abogado usted mismo.
Trataría.
At this moment, I have a lot of expenses.
At this moment,
I have a lot of expenses.
okay. Is he wanting to see if he can have an attorney appointed for him?
¿Usted quiere saber si le pueden colocar un abogado a usted? Sí. Yes.
Let him raise his right hand and be placed under oath.
Levante su mano derecha y lo van a poner bajo juramento. ¿Te jura y afirma?
Sí.
El testimonio que va a dar en este caso. La verdad. Pura verdad. Y nada más que la verdad. Y te ayuda Dios. Yes.
All right. He needs to fill out this affidavit. And I will come back to his case.
Necesita llenar este affidavit. ¿Sí lo puede leer? No. I'm going to help him with the translation of this document. I'm also here for another case. He's going to bring in,
Is he in jail or?
he's going to bring down, yes,
Okay.
a list.
Then
It's
we'll
for
bring you
Rubén
back. We'll
Barrientos.
come get you when we're ready for him.
All right, I'll
Thank
step
you.
out then.
Twenty 2023 CR 21 State versus Austin Davon Golden. Mr. Massengill?
Mr. Golden is here by Zoom, Your Honor, and he is in the Zoom lobby. He is a resident of Detroit, and he's a co-defendant in the conspiracy case we have, Your Honor. Wait till we get that pulled up. All right. Yeah, this is part of the conspiracy case, Your Honor, and we're here.
Let's let him get his camera on and make sure he's with us.
Oh, yes, Your Honor.
All right. What is the status then? It says it is part of the conspiracy cases that are set for trial January 20th.
Yes, Your Honor, and we continue to work to prepare for that. We have been unable to reach an agreed resolution of the case. I understand this is the last day to enter a plea, but given the leniency granted for Mr. Good, I'd ask the court the permission that in the event that we can work something out, I'll be happy to drive to whichever county Your Honor is in, but I'd like to have that opportunity. It's been rather difficult to prepare for this voluminous case, this very complex case, multiple co-defendants, with my client residing in Michigan, Your Honor. So for that reason, I would ask that we be allowed, in the event that we work something out after this date, to enter the plea. I understand, though, if Your Honor declines my request.
This case has been pending since 2023.
Yes, sir.
We are now in 2025. So, and we're going to be setting it, and it's set for trial in January 2026.
Yes.
So it seems to me that there's been ample time for preparation for this trial. Sometimes it just boils down to people don't really want to face the fact that they might be having to go to trial. Not you, I'm talking about, but General, what's your position if the, I know you have, if you'll just sit, you can sit there and use your microphone instead of having to come up here, but what do you want to do?
It's good for me, Judge. Well, Judge, I want to keep the trial set in January, so that we can.
All right.
Resolve. However, if he reaches out and we resolve this in a reasonable period of time,
I can almost hear her.
but I don't want us to be here on January 7th with everybody wanting to plead it back.
No, we won't. I'm not going to accept them on January 7th.
Yes, Judge. But if they want to reach out prior to January.
They have 60 days to resolve this case by an agreement, and then you'll need to get with Ms. McKinney, and we'll schedule a time to take the plea if they work it out. But after 60 days, they're going to trial regardless. So.
Thank you, Your Honor. I have one other very brief matter, Your Honor, if the court would be willing to take it up.
What is that?
It's just a status, Your Honor. It's my first appearance on page 23, State versus Billy Ray Perry, 2024.
Billy Ray.
CR 137. That case is with General Bryson, and that's his first appearance.
Who is it again?
Billy Ray Perry on page 31. Should have been an auctioneer, you know?
Billy Ray Perry.
Yes, Your Honor.
Judge, there are two other co-defendants on this one. Mr. Brown has one of the co-defendants. And then the other co-defendant, you had appointed Stephanie Lowe, and I think Mr. Spratt is asking to substitute in to take over for Stephanie Lowe, and he plans to file a suppression motion. He has asked if we would reset for VOP day to get a date for that suppression motion.
Do you have any problem with resetting this for September the 29th?
No, Your Honor.
There are 36 counts of burglary other than a habitation. 37 and 39 are burglary of an automobile, and then, of course, there are
They just broke into a whole bunch of cars.
Charges of theft that go along with the burglary. So we'll see what happens, but we'll set it for January the 29th, September the 29th for any status and motions.
Thank you, Your Honor.
Okay, one of y'all just texted me, asked me if I'm the YouTube guy. I am. It was a car break-in ring, yeah. Fun night out,
Again,
breaking
trying
into
to run
cars,
through some of
apparently.
the ones that are not in jail. 2023 CR 21 State versus David Keith Grimes Jr. That's Mr.
Yeah, but this is
Flanagan's
Tennessee.
case, and it's part of the conspiracy. Is there anything new on it?
The YouTube guy.
Put it on second call. 2017 CR 179 State versus Herman Lee Grimes. Herman Lee Grimes for arraignment on a probation violation.
Bench warrant shall issue. You gonna give him another pass?
You have a bond? There'll be a Sarah Fisher, or rather not a Sarah Fisher, there'll be a capias for the defendant. Bond will be set at $2,500. (2024) CR 242 State versus Brittany Dawn Hale. Mr. Final plea date January 7th.
She's here.
Ryan Hale as well. You represent him? Ryan Hale, come up, please.
Brittany was here. She's the lady in blue, I think.
Hale, your case is here today for you to determine, for you to advise us who you've hired as a lawyer. Who have you hired?
I wasn't able to get one. I was working and then I lost my job. And I've been trying to get in touch with the public defender's office here
Well,
for the
they
last
can't.
couple of weeks.
They can't talk with you unless they've been appointed by the court. So raise your right hand. Let's place you under oath.
I do.
All right. You're going to fill out an affidavit of your income and expenses for me to determine whether or not you qualify to have an attorney appointed. So it'll be under oath. Make sure you accurately fill it out, and I'll come back to you on the second call.
Read all this, understand it, fill it
2024
out,
CR
sign here.
137 State versus Seth Ryan Hall. Mr. Brown, that was your case. That's, we set for the 29th. All right. 2025 CR 1 State versus Gregory Arnie Hansard III.
Thank you, Your Honor. Mr. Hansard? Your Honor, on this case, there's another case that's set for a hearing on Friday with Mr. Hansard as a defendant, set for a hearing on Friday, Your Honor. Also, there is, that case is set for trial in January. I think it'd probably be best.
This case is set for Friday the 19th?
No, sir. We've got a motion in a case with the same defendant, and I thought that the two cases would track along with each other.
Okay, Friday the 26th.
Yes, sir.
Because I was going to say, we're trying Mr. Sherrick Vaughn on the Friday the 19th. So Friday the 26th. So now that I understand what day we're talking about, what exactly are you asking?
I thought these cases probably could track along with each other. This one's not ready to be set for trial. I'll ask for a status date probably in January. The other case is set for a trial. Sound right?
January the 7th.
Thank you, Your Honor. January 7th.
Cindy, thank you very much for the
2025
super
CR
chat.
141 State versus William Gracie Heggie Jr. Mr. Heggie is in jail, so do we have him down here yet?
You haven't transported anybody from
He
jail.
probably needs to be here for this motion, so we'll come back to you. 2023 CR 438
Bring
State
the
versus
in custodies.
Lindsay Taylor Hicklin.
Somebody's coughing. So I bought 2 toys on Friday. Maybe it was Saturday. Oh, yeah, it was Friday. Friday night. And I want to show you the toys. They're literally,
Right.
they're toys.
I'm going to appoint Mr.
Kids'
Mark
toys.
Odle to represent the defendant.
One of them is a little handheld little UFO that you toss up in the air and it floats. and you
Mr.
can push it around without
or the
touching it,
attorney
'cause it has
previously
sensors.
appointed, Vid Sanker, has been, now has had his license voluntarily suspended or whatever, if I understand correctly, for medical reasons or something. So we're having to appoint a new attorney. Mr. Odell will be appointed. Make sure he's made aware. Moving to page 20, 2025 CR 55.
Judge, can we give that last case a next status date?
Certainly. January 7th.
So that's one toy. And the other toy is a string shooter.
2025 CR
Which I
142, State versus Keenan. I'm sorry, that's in jail. 2025 CR 55, State versus Kevin Ray Hogan.
Let me see if I can bring him in here one sec.
We have attorney Tate Rohani.
Judge, he emailed me last week, but I did not, I
Didn't
don't
run and grab
remember
him.
anything about him being late. I can reach out to him and see where he is.
All right, we'll put it on the second call.
Okay, yeah, that coffer. is
2023 CR
headed to the
420,
coffin.
State versus Terriana L. Holbrooks. Ms. Holbrooks, you were to let us know today who you've hired as a lawyer. Have you hired a lawyer?
I'm in the process of still hiring Jay Clifton.
Who?
Jay Clifton.
Jay Clifton.
Uh-huh.
Okay, and how long is it going to take you to be able to hire Mr. Clifton?
I probably need like another month or two.
All right, this
What?
is again one of the conspiracy cases, General.
2 months to hire a lawyer?
Judge Turnbow has them.
Here's the UFO, which I've never used before. Do like that. And toss.
Oh, you're saying ADA Turnbow had it now.
Oops, sorry.
General Crouch, is there are any of the cases set for trial? All right. Well, I'm going to give her a status date of January the 7th. This will be your last time to hire a lawyer. January the 7th is your day to come back in and tell us who's representing you. And at that point, we'll determine whether or not your case is ready to be set for trial.
Okay.
Okay, thank you.
Thank you.
Next
This
case
one's-
is State
this one's
versus Dalton Ray
dangerous.
Hooper. That's Mr. Flanagan. We'll put it on the second call.
I think I just toss it up. and it
2025
floats.
CR 56, State versus Charles Lawrence Horn. Mr. Potter. It's here today because we have a motion in limine.
Well, it's also a status day. I think we have an agreement regarding the motion in limine, so we can submit an agreed order on that
All right.
matter. I've spoken to General Wojnarowski, and she advises that she wants to meet with the victim again and thinks a settlement offer will be forthcoming. So we don't have one yet, but I haven't seen that. I guess what I'm saying is there's a possibility we'll resolve it. So if we could set it for 1/7, that would be appreciated.
January 7th.
Thank you, Judge.
Okay, that's the UFO one.
That's what Mr. Potter was just saying.
I don't know how to turn it off. Oh, I turned it off. Charge of the USB-C.
2023 CR 97, State versus Carol Lee Hughes.
This is the string shooter.
Public defender.
Yes, sir. Sorry, Your Honor. This is Ms. Hughes. There's an offer for Ms. Hughes from the state. I haven't had a chance to talk to her about that. I would ask the court to please grant us another
I'll
status.
put it on the second call and let you talk with her about it.
Thank you, Your Honor.
All right, I'm told that Marcus Pace with the Department of Corrections is ready. So Mr. Andrew Lockhart. Good morning.
Spoken to the DA, we'd asked that this be reset for next week on the 29th. We may have a resolution.
All right,
I think it's set for trial in January currently.
let's bring in Mr. Pace with the Department of Corrections. Is that Mr. Churko? Oh, no, we have him in person. Okay.
Okay, so this is the string shooter,
All right. We have
which is making a mess.
Mr. Pace's cases are set for final plea day today, but it's been requested that we give you one more opportunity to resolve the case by putting it on the 29th of September. So I'll move it to 29th of September. Allows you have one last opportunity to resolve it.
Thank you, Judge.
All right, thank you.
It's a zip string or a string shooter. These are a blast, by the way. So you turn it on, and what happens?
2025 CR
is it
38,
shoots the
State
string
versus
out the
William
top, and
Condrey
it sucks it in the bottom. It's just a
Heinemann,
loop.
Mr. Potter.
Because of speed and gravity and everything else, it just floats in the air.
But I think that case will settle. We've been talking about it. I think it's likely that it will settle. So I would ask for 1-7 on that case as well.
All right, January 7th.
Thank you. Meet me out in the hallway.
2023 CR 420, State versus Billy Wayne Jamison. Mr. Saul. The final plea day.
I know, I think one of the co-defendants was just reset to January 7th. See if we can do the same, Your Honor.
This is the case that General Crouch is handling.
Yes, I believe it was originally Judge Turnbow's. and it's been-
Judge Turnbow was originally, when he
The
was the
assistant
assistant
DA.
DA, was
Yes,
handling it.
yes, sir.
Yeah. All right, January 7th.
Thank you, Judge.
2019 CR 237, State versus Ryan Dayton,
They're
Eldest
super
Joy.
fun. They're both under $15. That's where I got them anyway. I bought them at Sam's
Joy,
Club.
you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer?
I'll give you a link for a similar one, but I don't.
Do you want a lawyer
I
to
bought mine at
represent
Sam's
you
Club.
on your
Hang on.
violation of probation?
Yes, sir.
Are you able to hire one?
No, sir.
You want one appointed? Is that what you're asking?
Yes, sir.
Raise your right hand. Let's place you under oath.
Yes.
All right, you're going to fill out an affidavit of income and expenses, and I'll come back to you on the second call after you've had a chance to look at that, to fill that out, for me to determine whether or not you qualify to have an attorney appointed.
All right.
Have a seat and fill it out. 2024 CR 208, I'm sorry, that's a jail case.
I can't find one that says cheap as the one I got at Sam's Club.
2024
They're
CR
like $30 online.
236, State versus Cody R. Lackey.
That was addressed earlier with the co-defendant Lacey Lackey. That was set for status on January 7, Your Honor.
January 7th.
Here's a similar one. Let's see. Get link.
Moving to page 24, 2024 CR 67, State versus Gerald L. Lee. Mr. Himmelberg. Good morning.
Oh, yeah, good here from Mr. Hummelberg. He is on vacation right now. He would like a chance to speak to General Crouch and believes it can be settled by the next settlement date.
Well, this is the final plea day,
There
but
you go. If the general's okay speaking with me, here you go. We'll
So-
work on it today.
I'm sorry.
We'll work on it today then. Yes, sir.
Today?
Yes, sir.
All right, I'll
mark
put it
it
on
down.
the second call.
Good to go.
Twenty 2024 CR 146, State versus Calvin Wayne Lewis. Mr. Saul.
Anyway, I had so much fun with those toys.
Good
I
morning.
thought I would share.
You
I
know
played
where
with them all
you
weekend.
realize where you are.
I know. Your Honor, in this case.
Where are we?
Good news, we do actually have the evidence back from the team on that. However, one of our victims in the case is still in inpatient treatment. The state would like an opportunity to be able to speak with her and speak with probation. She has an expected date to be released from that completion date, and December, she'll then be going to drug court. So we're asking if we can put this on January the 12th.
Okay, one of the victims is in inpatient treatment.
January 28th.
Thank you, Your Honor.
I think I'm going to buy 2 more string shooters to scare Halloween people next month.
On page 26, 2024 CR 240, State versus Allison Nicole Mancuso.
Thank you, Your Honor. Would the court please second call that? I think we're going to settle it today.
All right,
Thank
put
you.
it on second call. Thank you.
Amazon calls it string magic.
Page 27, 2025 CR 184, State versus John Trevor McCord.
They call it string magic.
Good morning. You are here to be arraigned on a charge of simple possession of a Schedule 6 drug as well as possession of methamphetamine. You have the right to a lawyer. Do you wish to hire a lawyer?
Yes, sir.
You're planning on hiring one?
Yes, sir.
Sorry, that wasn't Amazon.
May I
That's
see his
Sam's.
indictment? Mr. McCord, we're going to provide you with a copy of your indictment. The question is, do you want me to read that to you out loud in open court, or do you want to read that yourself?
I'll just read it myself.
Show he waived the formal reading of the indictment and will enter a plea of not guilty.
Set for trial on January 7th.
On what day?
I'm sorry. It's November 7th.
I wish you would stand by the microphone. You're really ruining our court watching experience, ma'am.
Okay, but do you think you can hire one even?
Hire Mr. Baker.
Mr. Baker's like, you're going to do what?
All right. So what day should I set this if he has this other case? November 6th? November 10th? All right, I'm going to put this arraignment on, or your attorney status for November the 10th. That's before your next, before the trial date on your next case.
Yes, sir.
So if you hire Mr. Baker, make sure you get that done before November 10th, okay?
Right, sir.
All right,
Got it.
thank you.
All right, thank you.
They'll give you a copy of that indictment if you want to wait around. Mr.
Court's
Spratt here.
clearing
yet.
out a little
I have
bit.
not seen him yet.
More people coming in, but about
We'll
half of
pass
them are
Mr.
gone.
Spratt's case, Natasha Nicole Smith McCoy. We'll put it on second call.
Second call.
2023 CR 21, State versus Ronnie Tosh McCool is in jail.
None of the in custodies have shown up.
Moving to page 29. CR 75, State versus Carlandra KD Navarro.
She's wearing a cape.
This is on the docket today because you have successfully completed the community corrections program. And the
Good job.
state is now, or the community corrections officer is requesting that you be transferred to the Department of Corrections Probation Office. You understand that doesn't terminate your probation, it just changes from a more restrictive to a less restrictive type of probation. You understand that? And you'll have that probation for the remaining portion of your sentence. Do you understand that?
Yes.
All right, you've done a good job so far, so keep up the good work. We'll transfer you to regular probation. Make sure you know who you're supposed to see, okay?
Thank you.
All right, thank you.
Good job. It is a cape. She has a cape on. A cape with sleeves. What does that make it?
Do we have any inmates here
A
that I
sleeves
need
cape.
to
It's
deal
a
with?
duster. Ah. It's a cape, though. It's a duster.
China Lorene Henry McKeever. The attorney is Joseph Fuson. This is one of the 300, this is one of the conspiracy cases, is that correct?
What's the conspiracy? Can somebody
Mr.
tell me what the
McKeever, your
conspiracy
lawyer
was?
is not here yet. Because we have you on Zoom, I'm going to leave your case set for trial on January the 20th. As we have told others that are charged in that conspiracy case, if you and Mr. Fuson are able to work out an agreement, then he needs to contact the district attorney's office and we'll arrange to get you in front of me wherever I might be to resolve your case by an agreement, if that's possible. Otherwise, your case remains set for January the 20th. Were you able to hear everything I've said?
Okay.
All right. Thank you. That will conclude.
Yes,
your
sir.
work. All right. Thank you.
Thank you.
The car theft ring. I wonder if one of them's going to turn state's witness, testify against the rest, or was
2024
was it a gang?
CR52, State versus Jordan William Neely.
Daycare case is in July
Your Honor,
next year.
Mr. Neely's present.
This is the car theft.
Your Honor, this is set for a status today, and also a motion for bill of particulars. Regarding the status, I wanted to ask the court to grant another status date. In this case, the defendant has another case in Davidson County, and that's got a status on October 1, as I understand it.
That mic is picking up a lot of high-end noise. Oh, here comes the silent lady. She's going to come up and move her mouth, and we're not going to hear a thing. She's saying, reception. Trying to juggle, but I dropped the ball. That's what she's saying. That's all I can see. I have no idea what she's talking about. Half of them are already in custody for the car theft case. That's a ton of them.
What are we doing with the bill of
Microphonophobia.
particulars?
I suffer from the same thing. Bill of particulars. They want details from the other person about.
Passing it's appropriate.
Well, obviously, if there are images of sexual exploitation of a minor, then those need to be viewed in camera at the DA's office, and rather than provide a copy to the
Yes,
defense.
because then you're
So-
committing your own crime.
Okay. All right.
The report that's requested, it's anticipated that that would identify the images at issue, which would satisfy what's asked for in the bill of particulars.
All right, well, we'll set you another status date of January the 7th.
Yes, sir.
Hopefully you can resolve all your discovery issues and we can assign a trial date.
Thank you, Your Honor.
All right. State versus Deandra Rashad Portis, we'll put on the second call for Mr. Flanagan. Same thing with Heriberto Resanides. Put it on the second call.
Tennessee has a lot of crime.
2025 CR 176 State versus Eddie Jorge Torres Rojo. Mr. Ladner. Have an attorney named Ladner. For arraignment, did he file a waiver of arraignment?
He did file a waiver of arraignment, and he also told me that someone was going to be standing in for him today.
Problem with the waiver of arraignment is he signed on behalf of his client, if I recall this one correctly.
Yes, Judge, I did ask if there was any way he could get another one signed by his client and let him know that the court had the discretion to accept it or not, and he said his client had
I don't think his client hasn't waived anything if he hasn't signed off on it, so I am rejecting the purported waiver of arraignment signed by his lawyer instead of his client, and we'll set it for the 29th for him to bring his client in or have a valid waiver of arraignment, so.
He did let me know that Greg Flanagan was supposed to be standing in for him today.
Good luck with that. January 29th. That's fine. January 29th for arraignment. I'm sorry, September 29th. All right, moving to page 34, 2023 CR 420 State versus Rondell Newsom Shelton. Mr. Freeman. This is the final plea day.
I'm sorry, Your Honor.
Final plea day on the conspiracy count as well as the next case, 2024 CR 67.
Your Honor, Mr. Shelton has consistently told me that he knows nothing about this case. He knows nothing about the facts underlying the case. And I don't think we would be in a position at this point to plead.
All right, General Crouch still here? General Crouch, what are we doing as far as these, this new,
He's doing the Shaggy
420
defense.
conspiracy case? Are
It
we
wasn't
setting a
me.
trial date?
It wasn't me.
We can set a trial date, but I would like to have one other opportunity to enter pleas.
All right, I'm going to set another status date for January the 7th of 2026. Now that, Mr. Shelton, is the last day that we'll give you an opportunity for you and your lawyer to find out the facts of the case and to determine whether or not you want to resolve it by an agreement. If not, we'll set you a trial date, but it'll be later next year, okay? All right, thank you.
Thank you, Your Honor.
He's saying I just don't have any part
2025
of it.
CR 60, State versus Robert William Lee Shy on page 35. Mr. Baker. State have any opposition? January 7th. You said you represent the co-defendant. Who is that? Last name? Not. Maybe it should be, but it's not. It's not even on the next page. All right, it's on page 37, January 7th.
I would ask that we just.
He has a VOP set for the 29th. All right, so you want to set the VOP on the 7th as well? All right, his VOP will be set for January 7th as well.
Thank you, Judge.
All right. Twenty 25 CR 103 State versus Jamie Allen Stewart, page 36 of the docket. Public defender.
Thank you, Your Honor. On that, there is, I think, another co-defendant, and I asked the court for a status date on that.
All right, these status dates that I'm giving out are the last opportunity for these people to try to resolve their case by an agreement.
Yes,
I
sir.
don't want to set a trial date unless they have have exhausted their discovery and completed their discovery and had their opportunity for discussion. But once I set a trial date, then it goes to trial or they plead to the indictment. But it won't be a continuing cycle of and I'm not fussing at you. This is
Understood,
for
Your
general
Honor.
publication to everyone.
Yes, sir.
These continued resetting of the status dates are defeating the purpose of why we went to this status date program.
It's counterproductive.
All right, so for Mr. Stewart, we're talking about setting a January 7th status date.
Yes, Your Honor,
And that
please.
will be his final status date. So he'll need to resolve his case by an agreement on that day or we'll set it for trial.
Yes, sir. Thank you.
2016 CR 611 State versus Daphne Michelle Story.
A prosumer drone,
Locker, Jack
like in the
Locker.
$700 to $1,000 range, should work in about a 40-mile-an-hour wind, Jade. If you go with the big one, DJI, they have a few that will do up to
Is this
40-mile-an-hour
arraignment on the
winds.
VOP?
It's not
Yes.
optimum.
It's
It
an
skews a lot
arraignment
of
on a
battery.
third amended violation of probation. This is already set for January 29th.
Otherwise, you need a racing
We'll
drone.
provide you with a copy of that. Enter a plea of not guilty, Mr. Locker.
Yes, Your Honor.
All right, set for January 29th.
Blue Star,
Thank you,
everything's
Honor.
been
Thank you.
pushed. Apparently everybody in the county's been arrested, though. They're all here in court.
All right, let's go ahead and bring them in. Give me just the first one you got.
All these people sitting here and there's no cases ready. You might have to jump to another court.
All right, who is this inmate?
Your Honor, this is Cody Albu.
Cody James Albu on page 1 and 2.
Yes, sir.
What are we doing with Mr. Albu?
We've not reached an agreement on this. On behalf of my client, I would ask for another status date to continue trying to work out something.
What's the state's position?
The state's not talking, so we're going to jump to Judge Manning briefly.
Typically, we start work around 6. So we may leave the residence around 5. And
I just
we
want to
sometimes work late.
stay out of Fulton County.
So it kind of varies with, time. But then, of course, we work in different locations. So that's what I was asking earlier about possibly traveling out of town to work as well. So I know you mentioned something about just communicating, but possibly even keep the monitor and drop the curfew. I don't know.
He don't even have a problem with keeping the monitor if we could just get rid of the 24-hour curfew. That way he can work at any time, in or out of state, but that monitor will still be able to notify everybody where he is.
Well, that's what I was telling him. He can work anywhere out of state. All he's got to do is say, I'm going to Alabama.
Right, but I'm saying the curfew.
No, as long as he's working, if he is working, he's meeting with you, if he's at the hospital, as long as he's doing those things, even though there's that curfew, he can be out.
And so if he's not at work, if he's not with his lawyer at the hospital, you're saying he must be at home.
Right. Or if he's working at somewhere else that, he needs to let them know, I'm at this hotel in Anniston, Alabama. I think that confuses people.
Right.
I don't think it did it. I don't think it confused him in night court. I'm just.
His medical needs, his doctor is actually in New York as well. Is that correct?
New York.
And that's a concern.
I have
I don't
have New York Medicaid.
I don't want to.
I can't see it.
I mean, you're going to see a doctor. I mean, just have Mr. Patterson proof that this is the only doctor that I can see. And I'm going, and if Mr. Jenkins checks it, he could say, nope, here's a medical note.
As long as you can prove that you're going to see your doctor by a doctor's appointment, you'll be free to go.
Medical.
Yeah, I mean.
Medicals are exceptions.
Here it is. I always say a 24-hour. The only way you can, move is work, court, lawyer, job. You have to provide your location, your employer, the time you work, and the schedule. But the 24-hour. So those are the only reasons you can leave within a 24-hour curfew. That's what it means.
Is it possible to add my New York address on file?
He wants to put his New York address on file so when he go visit his doctor in New York, they'll know where he is.
I don't want his New York address.
Thank you both. Thank you.
All right, Fleet Fix Mobile Truck Repair
Mobile truck repair.
versus Aaron Flood, 2503184.
Fleet Fix Mobile truck repair. You break it, we come to you.
Okay,
and
ma'am,
fix it.
your name? All right, can you spell your last name?
H-R-A, B as in boy, N as in Nancy, I-C-K.
Wait a minute. H-R-A-B. Yeah, okay.
I-C-K-Y.
Brad Nicky. Okay, and your name?
What?
I already told you what I said. I know him. He actually did work for me at my house about 10 years ago. Cutting grass or something, right? Wasn't that about 10 or 12 years ago? So anyway, if you want me to get out of the case, I will. If you don't, I'm going to hand it. This question is whether or not I'm biased for or against. I'm not biased for or against anybody. So, but I'll be glad to answer any questions concerning my relationship with him if you'd like. And you can feel free to fire away, and I won't take any of that personally. Do you have any questions?
No.
And you don't have a problem with me handling it?
No, sir.
By proceeding in the small claims division, each of you are giving up certain rights. You're giving up the right to a trial. You're giving up the right to appeal my decision. You're giving up the right to hire a lawyer. In plaintiff, you're giving up the right to seek in excess of $6,500. Do you understand that, Ms. Rabnicki? And do you understand that, Mr. Flood? Do you wish to give up those rights and proceed here, Ms. Rabnicki? Mr. Flood?
Yes, sir.
I want to ask you a question, though. What is your position at Fleet Fix?
Yes, me too.
Okay, so you have personal knowledge of the facts and circumstances of this case. Do you have any other witnesses here? Any other witnesses here? Raise your right hands. Solemnly swear affirm under the penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ma'am?
Yes.
Sir?
Yeah.
All right. Go ahead and tell me why you're suing for $1,021.53.
So Aaron was discharged on June 16th. My boss, who was the owner of the company, reversed payroll for hours worked June 8th through June 14th that would have deposited into his bank on the 20th.
Wait a minute.
Before he was fired?
He was discharged the 16th. He was good due a check on June 20th. You just said that the office, oh, I see. So why would it be reversed hours between June 8th and June 14th?
So my boss thought that there was an outstanding laptop and passwords that needed to be returned.
You can't just take their pay.
So I rectified the situation.
Wait a minute. Wait.
I don't think you can just
So
take
go
their
ahead.
pay.
So on June 19th, I let Aaron know that I was going to cut a local draft to pay him for the hours worked June 8th through June 14th, plus the hours that he worked on his last day, June 16th, plus a reimbursement that he would have owed for gasoline.
So you were going to cut a check for the hours worked between June 8 and 14.
Was to cover the payroll that got reversed.
Right. And how much was that? Just those dates first.
The check total was $1,182.88, which covered $1,021.53 for the 8th through the 14th.
$1,021.53. Okay.
Balance was for the 1 day work, June 16th, plus a gas reimbursement.
How much was the day work June 16th worth? The point is, what you're trying to tell me is it's $161 roughly, give or take a few cents. It's actually $161.35 that Mr. Flood earned for his work on June 16th plus the amount that was owed in gas, right? Okay. So then what happened?
So on June 20th, his father picked up the check. Per his request, he wanted his father to pick up the check. So his father picked up the check. He deposited that check. Then on July 2nd, I received an email from our payroll service that the reversal was denied because the customer advised it wasn't authorized, it was improper, it was ineligible. So our payroll service paid his bank back $1,021.53.
Say that again.
Sure. So on June 2nd,
He
or
clawed
July
it back.
2nd, I'm sorry, I received an email from our payroll service saying that the reversed deposit was denied,
And that reimbursed deposit amount was for,
$1,021.53,
because,
because Aaron had, submitted something through his bank advising that it wasn't authorized, it was improper or ineligible. So without.
wait a minute. Submitted something through his bank that indicated that what was ineligible. Okay, so they went ahead and they were gonna they wanted to reimburse.
Unreversed.
Help it make sense, Judge.
Okay. And did they reverse the reversal?
They did.
So,
And they sent me an email saying I would have to recover that monies from Aaron, and they said that they emailed him as well.
did you play your draw 4? Or your skip?
So he was effectively paid twice for his hours worked June 8th through June 14th.
Do you agree with that?
No, Your Honor.
Okay, tell me.
So when I started at Pickles, I was promised 40 hours PTO, and then it would be paid out after full 90 days work. I worked there over 90 days. When they withdrew the money out of my account, it came from a separate company. It did not come from Fleet Fix Mobile Truck Repair. As well as when I disputed it.
PTO. What does that mean?
Paid time off.
Okay, so they agreed to pay you some paid time off after 90 days.
Yes, Your Honor.
And that check came from a separate company.
No, when they went to pull the money out of my account, it came out of Fleet.
Okay,
So that's why it got disputed.
Gusto handles our payroll.
who does?
Gusto, I don't actually deposit money into the employee's bank accounts. Money goes to Gusto. Gusto does the deposits for me.
Gusto. Is their payroll company?
This is a mouthful, kind of.
Got to be careful with the whole wage claim laws, things like that. You can't just be taking money.
Initially, your boss told you to reverse the payment that was made between June 8th and June 14th because this young man had a password and a laptop that needed to be returned, right?
Your Honor, the laptop's still out.
Okay. And then you cut him a separate check, right? And that check amount was for $1182.88. And he cashed that check, right? And you kept the money from that check, right?
Yes, sir.
And then that included not only the 8th through the 14th, but it included the work he performed on the day he was discharged, June 16th, and gas reimbursement for that date, or for what he was owed in gas reimbursement, for a total of $161.35, bringing the total from $1182.88, right? His dad picked up that check on June 20th, right? That's the check he took back that was deposited, right?
Yes.
Now, you're telling me this payroll services company that does your payroll for you said that he shouldn't have been paid between June 8th and June 14th, right?
No, the payroll service doesn't determine that. What the payroll service told me was, I have the email, that he had disputed the reversal. And so they were paying the money back to his bank. And I had to pay Gusto the amount.
Did you get that second check?
Yes, Your Honor.
So you did get second check from them?
Yes, that should have been 40 hours of PTO that so.
Your Honor, the check clearly stated on it what it was for, and he wasn't owed PTO because he hadn't successfully completed his probationary period because he was on a performance improvement plan. And per our manual, we don't even pay out PTO if you get fired. But the check clearly stated what the check was.
What?
All right, let's slow down one more second.
PTO is an earned
What
benefit.
day did you start there?
Started February 14th.
And you get entitled to PTO for after 90 days of how much? 1 week salary. Is that 90 working days or is that 90 days period? Would have to be 90 working days, right? And how many days did he work?
He had not completed. He was close, but he, like I said, he did successfully complete it because he was on a performance improvement. Which I have a copy of that.
What does that mean? They had an issue with his work?
Yes.
And they notified him that to him when?
The performance improvement plan was, the meeting was on May 28th.
Do the math here.
Do you have the copy of that letter?
Yes.
Can I see it?
Get it to the bailiff. Bailiff hands it to the judge.
So we're really down to, everything aside, as to whether or not he's owed for PTO, right? We all agree with that?
That's what it sounds like to me, sir.
Is that right?
Yes, Your Honor.
I also have our manual already.
I've also got state Michigan wage hour,
From who?
Michigan wage hour,
Okay.
stating that money was owed me and it was paid in full.
Michigan wage. The wage claim judges usually sort this out. And
You agree that the PTO is after 90 days work and they're entitled to 1 week salary?
Yes, if they completed their.
Right. And how many days did he complete? Can you tell me?
I can.
And are all employees on probation for the first 90 working days?
Yes.
if you keep him after 90 days, I don't care if he's on a poor performance improvement plan. He should get that money, I think. Man, I don't live in a state that doesn't make you get paid for what you've earned. Just move.
Why are you writing down period of time unauthorized deductions, June 23?
So they did not inform me that they were gonna be taking money out of my account. I was informed about the withdrawal out of my account until the bank informed me about it.
Do you have proof of some kind that you worked 90 days?
Yes.
Okay, let me see that.
Actually, Your Honor, I apologize, I did not, because I do not have, I was not given my employee handbook to start the company.
Was not given my employee handbook. You should still have pay stubs.
Do you have proof that he didn't work 90 days?
Other than the fact that he had not successfully completed it because he was on a performance improvement plan. And then our manual states that if you get discharged, you don't get PTO.
Yeah, but what if he worked 90 working days and then he was discharged?
He still wasn't entitled. Even if he had the PTO, he wasn't entitled to be paid it out because our manual says you don't get paid PTO if you're discharged.
Do you have that manual? Let me see that.
It's in the manual. Don't move to Michigan, guys.
Which page?
On the front, there's 3 different.
Curly Q NPR. Best 6 months ever.
I know, I was
So
hoping you could direct me to a page.
Page 11 is one of the pages. I hand wrote on the very front. There.
Okay.
There's the employee manual.
This.
judge is either going to be really disappointed in this manual or ask for an application and apply for the
It
company.
does say that when a disciplinary dismissal occurs, the employee will receive any remaining earned pay, and unused benefits will not be paid due to damages and undue burden to the company.
You're not gonna be waiting on it though. They went through it and that's statement that I got back, no.
I'm sorry, say that again?
That's the statement I got back from Michigan Wage and Hour. That was for, failed paid time off. Wow.
So he's saying Michigan wage an hour, whatever that is. Sounds like the wage claim judge, if he disputed the pay. I've had to do this with a company. It's not a fun process.
You filled this out, right?
Yes.
Pardon?
Yes, Your Honor.
Where was there a finding that they said you were entitled to this, though?
Give me 1 second, Your Honor.
Did you ever receive a finding saying that he was entitled to this, the company?
She's saying that he had said that things were squared away, basically. I did not get anything saying.
Yeah, oh, I apologize, Your Honor, that's right.
Okay.
So they didn't really rule in your favor, though. They said Department of Labor and Economic Opportunity Wage and Hour Division's records indicate payment has been made, which satisfies a portion of your claim. The balance of your claim has been closed per your withdrawal. Why couldn't they have been looking at that and saying it was essentially paid twice, and then you call them up and say, hey, I want to file this claim, and you got their money twice, and now you withdraw the rest.
Depends on the state. It's crazy.
Yeah, I know that wasn't very artfully stated. You agree you got paid twice, right?
Yes, I do.
Okay. Okay, so the question is whether you deserve the second check. You filed the complaint, and it looks like they somehow determined that you were paid in a portion of what you were claiming, and that then you told them forget the rest. How do I know that isn't on the amount that you should not have been paid if you weren't entitled to PTO?
Your Honor, I talked to them on the phone. I had told them that they would tribute money out of my account. I disputed it and give it back. They said that all monies were paid by then. That's what I was told by Michigan Wage.
But you got it twice. I'm going to give you a chance to tell me why I'm wrong, and I could be wrong, but it sounds like you got paid twice and you weren't entitled to PTO to me.
Yeah,
At least according to the handbook.
you got paid for 40 straight hours and 6.52 overtime hours. So even if we owed the PTO, which we didn't, based on the manual, it was still more than 40 hours and he was paid twice.
Your Honor, I've also got repeated messages that this is the only time I was notified that they would be taking money out of my account, was once they got notified that I had disputed it.
That's not true.
Okay, let me see it. Let me see what you have.
I've also got threats with, we got messages that we go through my pay as well.
What?
June 19th, I notified him that I was cutting a check for that reimbursement. And he gave me permission to put check to his dad on June 20th.
Wait 1 second.
Yes,
Wait.
Hold up. Judge is reading the details. I sense everything's coming together in the judge's head here, slowly. But he's going to get there, and he's going to give an epic ruling. Here it comes.
looking at this young man and I'm seeing that according to this book, you weren't entitled to PTO. And it seems like that's what all that this comes down to at this point. I'm not saying the dismissal was or wasn't warranted. But they make clear an employee may be dismissed at any time for any reason, but usually for disciplinary reasons at the sole and absolute discretion of management. I mean, you're clearly an at-will employee. In case of dismissal, your company may have at its sole discretion, give some notice if its intent to dismiss an employee, but the company is not required to give any such notice. This is consistent with management's intent to follow the doctrine of employment at will. When a disciplinary dismissal occurs,
Right to work.
the employee will receive any remaining earned pay, which you got, and unused benefits will not be paid.
So PTO is a benefit. I think the employee's out. He has to refund that to a PTO payment. Well, the amount of a PTO payment.
Is there any problem that I see that it work?
No. No. I mean, I don't have any signature from anybody here. This is the employee handbook. How do I know that he got this?
Every employee's given it, and then there's also a copy that is on board, for rehab, all of our required documents.
I mean, you just probably hang it like this, right?
Yeah.
You don't separate out by page the 39 pages and post them across the board, right?
No, it's just like,
And you are 100% convinced he didn't work 90 business days.
You're on that pay stubs that I can show that it did work. It's
Where?
Is a day, let me ask you, in this employee manual, if somebody's, let's say it's Christmas Day as an example, and they don't work, is that considered a work day?
No. What's it going to be, Judge?
Let me just check the thing, please.
We're going to head down to Texas after this. Check in with Judge Boyd. Guess who's back? Back again.
Let me ask you a question. When they get to 90 work days, they're not dismissed. What happens? They have to come in and say, hey, can I have my PTO check?
No, PTO.
no,
PTO's
because they, generally people will request those days off because they've been 5 days to use between then and their next anniversary day as a vacation, paid time off, they're not following. But we have a meeting to discuss.
If you want to run home and get your documents and come back with them, I don't think, I'm not saying that even if you have proof of 90 days that I can give you this money. I'll let you go get it if you want.
You're on the spoke. I have pay stubs because they had removed the pay stubs out of the account. So I do not have pay stubs from at all working at Pickles. I have bank statements from.
You are under oath. You're swearing under oath. You checked and double checked this, and he did not work 90 business days.
And like I said, even if he hadn't successfully completed it because he was on the verge of getting fired.
I got it.
He got fired.
So in a way, it's just paying them to take a vacation, right?
It's giving them vacation days, yes.
Young man,
Yes.
I'm sorry.
You owe this back.
We just cannot rule in your favor. Judgment for plaintiff. Now we can set up something. Can you pay this, or do you want to set up a payment plan? And you have a check with you?
He says he can pay it.
You have any problem with him going to get a check, bringing it back, handing it to you, and then we'll agree to do a dismissal order? Okay.
As long as the check clears.
Linda, I want to make sure that that happens. You go run home, get a check, and bring that back. And then I will make sure that I do a, Linda, have them do a dismissal order, a stipend order to dismiss, please, okay?
Okay.
Thanks,
Linda.
Philip
Appreciate
Trevino versus Mariah Stennett, 2502959.
Phil's been waiting. I just want to see what it is.
And I
If
want
it's
to
not
make sure you
exciting,
guys
we
get
can
your
jump.
paperwork back when you come back up here, okay?
Yes, sir.
Ma'am, come on up, state your name.
Hi, Mariah Stennett.
Sir, your name?
Philip Trofibio.
You haven't heard anything.
No, I was not hold with them, so
I just can't do anything.
I know.
I'm sorry. I'm gonna have to deny your motion, writ to issue. I really am sorry. I sincerely, I just can't make up my own rules here, and I'm sorry. I really am. So I'm gonna have to sign his writ. I wish you well, ma'am.
Thank you.
I really do. Good luck to you.
All right, jump.
Ernie McEwen versus
To an attorney, do you understand?
Oh, flowers.
All right, we can go off the record.
A ton of
How old are you?
I am 30 years old.
All right, so you're getting close. You're not there yet. You're getting close to the point where you're going to have more of your life behind you than in front of you.
Yes, sir.
If you have a drug or alcohol problem, once you're released from custody, if you can't find a place to help you with that, if I'm still here, you come back here, I'll find a place for you. But only one or two things going to end up happening if you continue this way.
They
Either
were
you're going to
irises.
end up in and out of somebody's jail or somebody's prison, or either somebody's going to end up having to identify your body, because the last time you use may be the last time you use. You understand?
Yes, sir.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. Thank you. What page was he on? All right, thank you.
Thank you.
We think Judge Boyd was on jury duty for a couple weeks. Maybe it was just vacation. Bayer County, Texas. One of our favorite courtrooms to visit. Flowers, purses. We need to. Oh, there's a purse. We can do a quick Google search on the purse.
And I see there's a hold for him for TDC. Is that correct? At least that's what it says on the docket sheet. All right, is there anyone else who's ready? Rafael Rodriguez. Hello, how's it going?
Going great, Judge.
How's the Spain thing going?
It's going.
You know, whenever I see the House Hunters International, I always get the feed. You know, there was one girl on there. She said her family moved them to Thailand when she was 16, and she was upset about it because she's like, I'm in the middle of my high school, but now she loves it. She's been there, I think she said, for 15 years now.
So I have a fun fact about house hunters.
Fun fact.
Yes, I had a friend who was actually on there,
Mhm.
and I didn't know this,
Mhm.
but they actually, all of those shows, the people have already found and bought their places, and then they film the show as if
Oh, yeah.
they're
Like
looking
it-
around.
What it always amazes me when people will say things,
Dark
like, for
secrets.
example, people going to Sweden. I would like property in the city center. We need 3 bedrooms, 2 baths, U.S. Western style kitchen. They'll go through all these things. Okay, how much money do you have to spend? We don't want to go over $500 a month. I'm like, good luck with that.
Try that here.
Yeah. All right, so what is happening with this case?
Judge, this is actually, I was supposed to be here last week, but I was dealing with a couple of murder trials in other
Yes.
courts. This is our
So
first
House Hunters is
setting.
fake,
Hunter and I have conferred. There's still some
allegedly.
evidence that I need to look through. So I can't say definitively that I've gotten all the discovery because I haven't had a chance yet. So we're just asking for another conferring setting or a pretrial setting so I can finish going through the evidence.
All right, Norma, I need a 45-day reset. And you all need to make sure you have discovery and state if you'll be prepared on that day to tender an offer.
Yes, ma'am. That's it, Judge. Thank you.
All right, let me get a date. All right, November 6th, once you sign the reset form, you're excused for dressing appropriately for court.
I was cold.
Hey, we don't say that word in this court.
Last week, I was like, I gotta bring it to
Thank you, Judge.
Thank you.
Thank you, Judge.
Deputy Laura, he's complaining about the cold in here. We don't do that.
Who's the guy with the bow tie?
Thanks. Have a good one, Hunter.
Oh, Hunter is a prosecutor. BK is appealing. Where did you get that, Barb? There's a very, because that has, the only reason he could do that was for ineffective assistance of counsel, right?
All right, Summer Bailey. Hi, James. How's it going?
Hey, you let me go to the cardiologist. We're gonna get all the results tomorrow. Find out if I'm dying or not. I don't think I am.
It's going to be fun.
No, not with the blood pressure, 114/64. That's low, man.
Be great.
All right, take care.
All right, have a good one.
I was teasing what's his name, about the belt buckle. He must have.
Well, keep me posted on the health thing. All right, court is calling 2021 CR 7574, State versus Summer Bailey. Can I have parties announced for the record?
Megan Galloway for the state.
Actually, like attorney for Miss Bailey.
And are you Miss Bailey?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I don't understand it, but yes, I have it in my hand.
All right. So basically what that is, that's a document.
Yes, ma'am.
And that document is complaining, and I'm going to tell you in layman's term, it's complaining that you are on probation, that you're currently on probation. Do you realize you're on probation?
Yes, ma'am.
And they're saying that the conditions or instructions that the court has given you,
Yes, ma'am.
they're saying that either you didn't follow it or you violated it in
Yes,
some
ma'am.
way. So do you understand?
Yes, ma'am.
All right. Are you the same Summer Bailey who was placed on deferred adjudication in 2021 CR 7574 for the offense of aggravated assault with a deadly weapon on September 10th, 2021 for a period of 3 years and extended for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 12th day of June 2025 in Bexar County, Texas. Defendant Summer D. Bailey did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant failed to attend outpatient treatment in violation of condition number 43.
How do you plead to that? True or not true?
True. I did not complete it.
All right. Did you understand by pleading true to violation of condition number 43? Court could find it true, grant the motion, sentence you to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 43?
Yes, ma'am.
Court will find violation of condition 43 true. Is there a proposed agreement?
There is, Your Honor. Just for the record, we do waive and abandon the other, or the remainders violations.
Oh, I'm
and-
so sorry. I don't have that report, but
Sorry.
No,
There's-
no.
There's a supplemental that.
thank you for waiving those.
And the agreement for the court's consideration is that you grant the state's motion, revoke the defendant, sentence her to 4 years TDC, and the state is going to take into consideration clause number 2025 PF 35078.
Okay, while they go about revoking this, let me just
All
pause
right,
for
are
a
you
minute.
asking the court to follow that agreement, Miss Bailey?
Let me pause, turn off her voice for a minute, and just take a minute because somebody asked me to do something, and I'd be happy to do that. Hey, Dayton, how's it going? Just want to say hi. Thanks for watching. Appreciate it. Have a great day. That's all.
Miss Bailey? All right, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
I don't know how to answer that question.
It's a
All
yes
right,
or no.
so
I mean, I know what it means. I
do
just
you
don't,
understand the question?
I understand the question. I just don't know how to answer it properly.
You want to speak with your attorney about that?
Yes.
Really. I guess I'll waive it.
No. I don't want guessing because
I know.
this is very
I know,
serious.
I know it is. I know
So,
it's very
here's the
serious,
thing.
but nobody
Do
will.
you- When you are on probation in a court, the state and the defense, they're really not allowed to have an agreement and then I have to accept their agreement. The agreement that they've reached, I don't have to accept it. I can sentence you to 20 years in prison.
Yes, ma'am.
Now you're telling me you want me to follow the agreement that you've had with your attorney and with the state. Is that correct?
And I said, yes, ma'am.
All right. So if you want me to follow that agreement, then my next question to you is, are you going to waive your right to appeal? You may want to discuss that with your defense attorney.
I don't see anything that
ma'am.
says BK
All
is
right. So
appealing.
are you waiving your right
Yes,
to
ma'am.
appeal? All right.
I don't think he
The
can.
court then is
It's just extremely limited
going to follow
reasons.
your agreement. The court is going to grant your motion. I'm sorry, grant the state's motion, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served. The court will request the therapeutic community. There's an affirmative finding of a deadly weapon. There's to be no contact with Richard
And
Cantu. Take in consideration 2025 PF 35078. Is there anything else from either side with regards to sentencing?
Judge, just really briefly, it looks like she did complete safety and custody. And I believe she has 273 days credit for that.
All right, so I'll give credit for any time served for a successful completion of inpatient treatment.
Hey, well, I think I'm going to see if we can find that and go watch
All right,
that.
did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you sign it?
yes, ma'am.
All right, because this was a plea bargain agreement that you've reached, because I followed the plea bargain agreement and because you waived your right to appeal, do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So,
Okay, we're going
I
off the channel for just off that one.
I was like, I guess I
Is this
can't
the
argue
one?
with that logic.
Is this the one, AWOL?
Good morning, Ms. McNeese. This is Judge Middleton. If you give me just a minute, we'll get situated here.
Okay.
This is a cool one. Hang on. If this
This
is
is 241278FY, People versus Danielle McNeese.
just happened 3 minutes ago.
All right. You want to take this money with you? Okay, I don't want to leave the money here. Well, I was saying, we got it. I need 2 more dimes, that's it. For the first.
It is a beautiful morning. We're gonna switch from our civil case to some criminal cases.
Yay.
With the assistance of Mr. Stickley, we're gonna do a arraignment here. This is a bench warrant arraignment for failing to appear for a sentence in the matter of People versus Danielle Marie McNeese. Is that you?
Yes, I'm sorry, it is.
All right. Your lawyer was Mr. Luke Knopfinger. I tried to see if I could get his help this morning, but he wasn't scheduled to be here. So here with us is the Chief Public Defender, Mr. Keith Stickley. You were originally charged with possession of methamphetamine as a felony. The case started in front of Judge Pattison, and then somehow it got put in front of me. You entered a plea to that charge, and we set the sentence for August 11th of 2025, and you didn't show up. So we waited a few days, and then we issued a bench warrant for your arrest. We also did a notice to forfeit your bond with the bonding company, but they usually don't do anything about it. How did you come to get arrested this weekend?
This is the last one.
I was
3 minutes
at
ago.
Walmart,
Walmart. It's got to be a Walmart.
In what town?
Kalamazoo. I've been in jail for like 10 days now. I was in Kalamazoo on hold for St. Joe to come and get me for like 6, 7 days.
She might have a pending charge there, Your Honor. I'm not exactly sure yet.
Do you have a charge in Kalamazoo?
I'll have a court hearing. I should get paperwork.
All right. I tried to find a time that your lawyer was going to be here, and I couldn't find one. So I'm going to cancel your bond. You don't have a presumption of innocence. You've entered a plea, and then you didn't appear for sentence. Were you in jail in August in Kalamazoo?
I had 3 rides set up and they all fell through on me.
All right.
I'm not buying that. Who sets up 3 rides?
Do you still live at Edward Street?
I do right now, but I possibly am getting an apartment, and I was supposed to start a job this week.
Excuse me, where is that?
I was gonna start cleaning houses with my friend Scott.
Abel's telling me this is not the right one. This one, we are 123.45. Okay, we're gonna be up here. It's on the other end of the live stream.
Parents I've been working with. And as I told Ms. Parker, let's hope you can't pass this on to the next generation of your kids. So you go down to the probation department, they'll get you plugged in is what you need to do.
Thank you, Your Honor. Thank you, Your Honor.
All right, this case right here. Thanks, AWOL, for the clarification. I appreciate that.
All right, Miss McKay. I talked to the sheriff at the fair. He had a booth, and he's the kind of sheriff that has a booth at the fair, and will sit there and people will walk by and talk to him about things that are on their mind. But I just call him up if I had something on my mind. But anyway, he's doing a great job as our sheriff, and he's accessible and easy to talk to.
Not an endorsement.
He talked about how many fatal accidents we've had this year. Our law enforcement citation numbers are way up. Much more tickets have been written, much more tickets have been authorized by the prosecutor, a lot of drunk driving arrests. And in the first 6 months of the year, we had 14 fatal accidents through June. Last year altogether, we had 8. Between June and now, we've had about 8 more. So we probably had 20 fatal accidents so far, 20 deaths. Some accidents resulted in more than 1 death. And some of that's a factor of people driving around with very high blood alcohol levels. So let's change our theme here. This one does not have to do with alcohol and drinking and driving. It may have to do with alcohol, but doesn't have to do with drinking and driving. This is domestic violence. It started as assault with a dangerous weapon and was reduced to domestic violence second offense. The defendant is Jeannie McKay. She's here with her lawyer, Mr. Paul Gibson. I'd hope to get some input from the complaining witness in this case. I let Miss McKay out at the time of her plea and set the matter for sentencing. She didn't get in any more trouble, apparently. I'd hope to hear a little bit about maybe mental health counseling and get some input from the complainant. Mr. Bates apparently doesn't want to talk to us or provide any additional information. Mr. Gibson, what would you like me to know?
It's my understanding that the defendant and the victim are no longer together, and that, you know, it sounds like it was a mutual relationship where there was domestic violence allegations, I guess, that she had made against him. In this incident, she herself was, I guess, suffered a laceration to her leg. Apparently, after she hit him, he pushed her to the ground, apparently. So this was a bad incident all the way around. The defendant went straight to jail. It's my understanding that she served 14 days. The victim is not interested, I guess, in getting forth any input. He didn't ask for any services. He asked that they not contact him. So I'm not exactly sure if I'm thinking that if this court, if the 14-day jail sentence would not be enough of a penalty in this case, I would ask the court to consider probation. The defendant has a mental health history.
Actually, that's incorrect. I have a history of medical fraud. Yeah, big difference. Every time I tried to report crime, I ended up in the mental hospital.
Okay.
Not really my issue, but yeah, big problem, as a matter of fact. And so I've had issues with reporting crime since. There was no mutual relationship. This man had me trapped for 2 years. He lost me my jobs by stalking me outside my work. I was moving out of state when I ended up meeting him. And so, I mean, I feel like it's entrapment, generally speaking. I mean, and to be on probation in this state for another 2 years after I planned on moving years ago when he lost me my jobs, I couldn't get out of the state.
Do you plan to move now?
I would love to move. Yeah. I mean, I don't want to live somewhere
Well, where do you live now?
I'm on Sandy Drive right now.
All right, with who?
I don't know what to do.
Well,
This
who
man
lives there?
He has destroyed, it's an old friend, but he committed suicide or whatever. I don't even know.
The friend, so you're living, who owns your house?
It's Brad Swoveland.
Brad
Swoveland.
And he's deceased? All right, so you're in the house, but he's not there. Does anybody else live there?
Mm-mm.
Do you pay any rent?
Mm-mm.
They're probably gonna move to evict you. Well, Mr. Bates has got his own problems, and one of the problems had been methamphetamine. There's a pending bench warrant for his arrest right now, which may have to do with why he doesn't want to have anything to do with this.
I actually even contacted a DACES shelter or the, sexual abuse shelters and domestic shelters prior to this, like 6 months earlier, and they wouldn't let me in. They said I didn't qualify. So it's like, been known to me why I can qualify for a domestic assault charge when I couldn't get into a shelter when I needed the help. Do you know what I mean?
I guess I don't have an answer to that. But so what's your plan? You can't stay in this place not paying rent. Do you have relatives or friends in another state?
I was planning on just moving out of the state because if I get put in mental hospitals when I'm trying to report crime, I don't feel like it's a safe place for me.
Well, there was the earlier incident in Three Rivers. This is a DV second. There was an earlier one.
That
which-
was the Jim Littlefield.
Yes, so that was also, there's a mental health.
It was
aspect.
actually, no, there wasn't anything in Three Rivers.
I thought it was over on like 7th Street or something.
Now that man is out of his mind. He said he was gonna sell me, and I obviously protested. And when I told him I wasn't crazy because they were trafficking girls, he kicked me out of the house because he feels guilty, I suppose.
Well, that's a good house to get out of.
Wow.
Ms. Canfield, any additional input?
I'm concerned about, when I look at Mr. Bates's history, I see in addition to methamphetamine and multiple controlled substance convictions, a conviction for violence as well. I think that probably
Can I
if
say
she
one
wants
more
to
thing?
leave the state, I don't know that probation would be helpful. If she's reporting that there's been violence and sexual assaults against her that haven't been dealt with, that's concerning. And it's not very often that we see it, but we do see what we call reactive abuse occurring towards a perpetrator who has been longstanding abusing someone, where the victim finally reacts.
Yes.
I presume that may have been the case here,
It's
according
the
to
prosecutor
what
talking.
Ms. McKay is saying. I think possibly a short jail term or credit for time already served would be appropriate, and no probation, and let her move out of the state to a place where she feels safe.
Those are my thoughts. I know Mr. Bates. He's bound over to circuit court on a methamphetamine charge right now. He's got a pending bench warrant in my court, and there's some assaultive history, and it's hard to tell what was what. They made a choice to take her to jail. She was there for 14 days. She got no real ties here, and she's living in a odd circumstance. When did Mr. Swovlin die?
Like last November?
So you've been in there since November without paying any rent?
No, I haven't been there that long, but I don't know.
All right, well, I'm gonna give you 14 days jail credit, 14 days. 0 fine, $125 in costs. And I'm gonna give you until November 15th to pay that. You're free to leave the state. There's nothing here for you but heartache. Do you have any income? Do you get disability or anything?
I was working, but he exhibited like stalking-like behavior outside of my work, and I got
Where
fired.
did you work?
At the Saginaw Golf Course. I was gonna work as the
Oh, yeah, you told me that.
grounds crew and bartender, and then I got fired for the police vehicle.
All right, we'll give that to her. You're free to go do what you want.
Thank you.
But I would not recommend you have any contact with that gentleman.
Thank you.
But there's a mental health issue that underlies this, and I think unless you start to get some way to address that, you're gonna be right back in it. But I couldn't tell anything about drugs or alcohol regarding this. There's nothing in the report. They didn't show any blood alcohol on your booking sheet. I know that methamphetamine is the underlying theme with Mr. Bates. I don't know what we're dealing with, but 14 days, credit 14 days, you're free to go.
Thank you.
She's moving out. She interrupts her lawyer, argues successfully her case, and she's done. Head back to Judge Boyd. This guy has an octopus in his pocket. I kid you not. Look at this. Look at this lawyer. Is that an octopus? Am I seeing that correctly? She didn't get any mental health help, but there's nothing to hold her over any further, and hopefully she can get it where she goes. Why am I not?
You can try and get that taken care of after this. But I thought the easiest thing, if the court would entertain it, would be to do the plea and then come back for, I guess, formal sentencing. I don't know if you don't do that, then
No, and let me just tell you the reason why I'm not going to do it. Y'all are telling me that obviously he has a drug issue. And would it look like if I have him plea? We don't do anything with it. He's just bouncing around free and he ends up getting a hold of some bad drugs and dies.
Understood, Your Honor. Well, that wasn't the state's, that was my suggestion.
No. I'm just saying that's why I'm not doing it. Because sometimes I like people to understand why I'm not doing the things that maybe seems like that's the easy way to do. So I'm calling it back for a contested hearing.
Yes, Judge.
You all need to get whatever is happening in misdemeanor court taken care of, and we can come back on September 29th.
The only thing I would ask, Judge, is the legislative continuance is through October 4th. Any chance I could do it the week after that?
I can put it down for October 6th.
Perfect, Judge.
All right.
Thank you so much.
You're welcome. No problem. Ms. Ferguson, if you'll put this for October 6th, and it's a contested probation. On this case, they think they've worked out things. So if they have not, it'll be contested. If they have, then it won't.
That's how it
All
works.
right. This is my suggestion to you. Obviously, there's a drug issue going on with you. When you leave court today, after whatever happens in misdemeanor court, you need to find you somebody's AA meeting or NA meeting, and you need to be going to that daily, because the last time you use may be the last time you use. Who's your support system for you?
I really have it myself.
Right.
No.
And my uncle.
No.
All right. You don't parents? No.
No, I don't.
Do you have any type of relatives for support system?
My grandparents and my uncle.
All right. So here's the thing. You do not want your grandparents or your uncles to have to come and identify your body, right? So when you leave here and you finish with your business here today, your attorney can tell you there are NAAA meetings all around town. There are even some that you can do online. So instead of using drugs when you feel like you want to do it, go walk into an NAAA meeting. And there are people there who will help you. You understand?
Yes, ma'am.
All right. We'll see you back on October 6th.
Thank you, Your Honor.
Thank you. And thank you for dressing appropriately for court.
Thank you.
All right. Have a good one.
All right, I think we're going to be headed to lunch here in just a minute as we get ready for Karen Reed in the afternoon. It's the plan. It's the plan to watch the
Thank you, Your Honor. May I excuse
Yes,
civil
have a good
stuff
one.
going
Thank you,
on
Judge.
right here.
Counsel,
Counsel.
you may want to talk with probation and see if in the past they've tried him for felony drug court. That may be a good fit for him.
We'll do,
So
Judge.
if you talk to probation now, they'll be able to let you know.
We'll do.
Lacey,
Thank you,
for
Judge.
giving
You're welcome.
5 memberships. That's super generous. Delina Foster, member for 16 months. 16 months, counting months till I get to hear RAL OG
Oh,
to me.
yes.
It's the little things in life that help me keep me looking forward. Delina, that is awesome. That is so cool. Thank you. 16 months. That's awesome. I think we're going to go to lunch. And I haven't made the portal yet because I haven't finished the thumbnail. So I think we're going to.
All righty. Thank you.
Let's see. It might get spicy. It might. We're just trying to see how exactly we're going to connect to it. So I'm trying to get that lined up. Don't have that sorted out quite yet, but I want to see how it goes.
Norma, is there anyone else who's ready?
Ms. Moore, 11-5 down.
More.
All right. Thank you.
Oh. Thank you. May I put you on?
Yes.
So we looked into it. She's going to do a re-referral. At first, she said that he got rejected or did not qualify because he had a warrant, but the warrant's been taken care of. So she's re-referring, doing a re-referral out. Hopefully, we'll have an answer.
All right. And you may want to make sure that you talk to him about it and tell him it's a difficult program, that it's probably a better fit for him because they have a lot of support.
We'll do. Thank you, Judge.
All right. Thank you.
Thank you so much.
All right, Manisha Moore.
Yeah, I've got some homework to do. So I want to go up here. Back.
Where do I stand? Right here?
Oh, you're over there on that side.
Over here, okay.
All right, have you all had a chance to confer?
We have.
And did you get a chance to review the file?
Yes.
All right, court is calling 2025 CR 009091, State versus Manisha Moore. Can I have parties announced for the record for the state?
Melissa Alvin for the state.
Brian Bernard for the defendant.
And are you Manisha Moore?
Yes.
All right, the defendant has filed a motion requesting a bond. She was a no-show for court on September 11th. Defense, do you have any witnesses?
Yes, my client, Your Honor.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name
think
for
we're
the
set
record.
Monisha Moore,
How did
Monisha.
you get out of jail?
PR bond.
When you was released from jail, did you communicate with the court about your next court date?
Yes, I called every day that week, and when I called someone, don't call no more, they send me a letter in the mail about my court day. I never got one.
So did you ever receive written notice to be in court on September the 11th?
No,
And you was, when did you become aware that you had missed your court date?
when I was arrested, when I was in jail in Travis County on the last Friday, not this Friday, but the Friday before.
And how long have you been in custody?
For like 9 days now.
And by being in custody, did it cause you to lose your job?
I'm about to lose my job. My supervisor said I have to Friday to come back.
Okay, thank you. Nothing further.
All right, any questions?
Did you give them your current address, ma'am?
Yeah, I gave them my address. Oh my God.
And is that where you returned back to when you got out on bond?
Yes.
Nothing further.
Oh. So, any objections to the court inquiring?
No.
Ask away,
So
Judge.
you said you were calling the court every day?
Yeah.
What court were you calling?
So the jail I don't know, they gave me a number to call, and I gave them my case number, and they transferred me to the court, and the lady told me don't call back no more. They'll send me a letter in the mail, and I never got a letter in the mail.
All right, so did you call this court?
I don't even know. So when I called the jail or the courthouse, I gave them the case number. No, I don't
The
know.
187 court.
I don't even know what court I called.
Did you take the name of any person you spoke with?
No, but I can get a printout of my phone bill.
Oh, no, I'm just wondering.
She's got
State, what are you
receipts.
requesting?
$10,000, Your Honor.
All right, and is that based upon the fact that she did not appear?
That and the original, I saw that the original bond was $5,000.
All right. So would that change
need
if
to
she
go.
in fact called
I haven't been.
and said that she would send a letter? I mean, that she would receive a letter?
If she had called in,
If she had called the court and the court informed her that she would receive a letter? I don't know if this is true or not, but
Right.
would that change your opinion at all?
if she actively made an effort to try to find out and we could verify that, then yes, I would feel like she was not entirely at fault for not showing up to court.
Okay. And here's the court's other question with regards to her finances. Do you have any finances available to you? I'm sorry, any funds available to you?
I can get it from my mom, I guess.
Yeah, I mean, do
How
you
much do you
personally, do you have any money in your bank account?
No, I only got $194 on my books.
Okay.
194
And
on the
state,
books
are
is
there
not going to
any
go very
other
far.
criminal offenses
That are pending?
that are pending, or what is her criminal history?
There are none that are pending with us other than this one.
Okay.
She does have a relatively lengthy criminal history. She has
Pages.
convictions or adjudications for bail jumping and failing to appear, driving with license invalid, failing to ID fugitive, theft with the theft under 100 with the previous conviction, and 2 theft 100 750s and 2 theft 50 to 500.
That changes everything.
All right. Just one moment.
The bail jumping, failure to identify fugitive, all that changes things. It's hard to let people out just on their own when they have a a pattern of not doing well in those same situations. We're about to go to lunch. When we come back, we expect to be picking up the Karen Reed civil lawsuit situation. We're hoping. Keep our fingers crossed.
All right, this is what the court is going to do. Counsel, I'll note that you have been present in court. Ms. Ferguson? Yes, sir. I need a 30-day reset on this case.
Your Honor, do you guys have afternoon dockets ever?
What date? All right, October 23rd. And we'll put that at 1:30, Ms. Ferguson.
Thank you, Judge.
You're welcome. All right, so with regards to the fact that she's previously jumped bail before, there are some new laws that are in place with regards to setting bonds when persons have previously jumped bond or absconded before while they were on bond. So I need to just do a little research. I'm aware of the law, and I believe I know what legally I'm supposed to do, but I just want to double check. All right. So it'll take me 2 minutes.
Oh, I'm like, oh, my job.
Oh, no. So here's the thing. You may end up losing your job anyway, based upon what the new bond law says because of the history of bond jumping before. So I just want to review something to make sure that I'm setting it appropriately. So just give me 2 minutes, okay?
Judge can do little bit of Google. Hey, Google, what is the minimum? No, just kidding. A couple facts about the Karen Reed trial. We have a different judge. It is not Judge Beverly Cannoni.
Oh, just have a seat.
Because it's a civil suit. But a lot of moving pieces are going to happen today, so we're hoping to be able to catch an eye on that.
I was told counsel wanted to see me at sidebar.
Yeah, that's what I'm talking about, Ricky. I want to see what happens with this, but at the same time, I need to go to lunch. I've got to run to the post office. I've got things to do on lunch. Walger, here's a great place to watch if you don't want the drama. We don't get into it. We just don't. We're here for court. Starts at 2 o'clock. If we come back right now, it'd be about 1:45-ish. Does that sound good? I still haven't made the thumbnail. I'll do that in just a bit. Judge is still using the Google machine. Ivy Berlin says I'm here for chat.
All right, anyone else ready?
At Walmart. Oh, she's taking something else. Okay, we're bailing. We're done. We're done. If she's going to take in other cases and clips of our excitement, awesome. All right, we're going to wrap up this morning's court hopping. Realize the case we have followed last week that went to a verdict last week is going to be back on Wednesday for the sentencing portion of the trial. So we're going to continue with that one. That's the Soto one. And that's death penalty. So that's the question. Is it going to be death penalty or not? If they say no death penalty, then the judge sets the rules. If they say yes, then that's where it happens. Okay. All right. I'm setting off everyone's Google machines. I'm sorry. I've turned to the post office. I might ride my bike there because, I could use the exercise. It's an e-bike, so that's the joke. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again. About 1:45-ish. 1:45-ish. No portal. You gotta click the subscribe button. You gotta click the notification button. And then join us back. It's gonna be a lot of fun. Y'all have an absolutely fantastic lunchtime. I'm gonna go play with those little toys and go to the post office. So we'll see ya. E-bike is not exercise. I have to push it up and down the stairs, Lois. So that counts for something. Because currently, I store it in my house so it doesn't ride off on its own and never see it again. Don't pedal too much. I'll try not to break a sweat, if that's all right. We'll see you on the flip side. You guys have a good one. Bye-bye.
Thank you, sir. You're my new best friend.